Yep. Look like.
Okay, ready? We're done?
To adjourn?
Not quite. Okay, we should be good to go now.
Okay, welcome to the February 4th Village of Mamaroneck Zoning Board of Appeals meeting. Before we start with the agenda, Meg Jurgen is going to make a motion to go into executive session.
Making a motion to go into executive session to discuss pending litigation.
Is there a second?
Second.
Okay, then Abby, voting.
Yep. Huh?
Greta,
Yes.
are we all frozen?
It's not that cold out.
You're frozen.
Seem
Your
to all
face
be
is
frozen.
to us.
Or is it just that's what you look like to me? I don't
Yeah,
know.
you look frozen.
I think you're frozen, Robin.
Frozen.
I'm frozen?
Mhm.
Now you're not. Now you're unfrozen.
Interesting, because from my perspective, everybody else was frozen. So, okay. Okay, so sorry, Greta, I was asking you if you vote yes as well.
Yes.
Dave,
Yes.
Meg,
Yes.
and I vote yes. So we are now going to go into executive session. All of you should have that separate link that that Amber sent. So you should leave this meeting, because you can't be in two Zooms at once. Leave this meeting and then open that meeting.
Wait a second, there's a separate,
It was in a different.
oh, I
email.
just, 6:52. I just got it. I'm sorry.
Okay, but yeah,
So I have to leave this meeting?
Yeah, and then click on the link for the one in the other email.
Will I be able to
Come
come
back
back?
to this one. I think.
All right.
Bye.
Very sophisticated here. I got 2 meetings that have to figure this out. Yeah, but it's not working now. Because it's not there. Yeah, I don't have it. I go back into it, the same one?
Probably want you to go to a different meeting.
You should have received an email from the village planner. All right, let me go. I gotta call Robin, I guess. Oh, here we go.
Yeah, on your phone if you want.
Where is this thing? I can't find it.
So we all came back to the regular meeting because we can't get into the other one? Amber, are you there?
Meg, I think Dave was having problem getting out of the regular
Hi, Meg.
meeting.
I'm on a call with Robin. I'm trying to figure out how
Okay,
to set
no,
up
we pop back
because
in,
I'm,
Frank. Yeah,
yeah,
we got problems.
because I'm the administrator for both. Zoom is not allowing me to host both at the same time. So we're working on that.
Okay, I'm gonna sit here to make sure, because I'm just gonna sit here.
Can anyone hear anybody?
I can hear you, Dave.
Ah, great. Good, Frank. How are you?
I'm good. How are you?
Good. It's nice to have someone to talk to.
At the bottom right of your screen, if you put your cursor there, you should be able to leave the meeting.
No, it's not that. It's that when we tried to enter the other one, it says the host is not letting us in.
Ah,
Amber's
Okay,
working on
that's-
something because there's something preventing from that meeting to actually happen.
okay, that's
So
beyond me.
David and I decided to come back in and see what was going on.
See?
Hi, Lori Lee, how are you? You're on mute. Yeah, there
Hi,
you go.
There
I
we go.
went, I couldn't get in, so I came back to you.
Yeah, so did we.
How are you?
Okay.
Feel like you're worried you're the only one not getting into the party, you know?
Oh, yeah.
Everybody's having a party without you.
Did everybody order? All right. All right, so I get Frank, Meg, and myself. That's all right. We're good.
All right, we're good.
We're good. It's good to be good.
We got an attorney, we got a planner, we got a couple planners.
We got whatever we need, whatever makes it through the day, right? It's a lot of fun. You've been going, I
Amber, are you still there?
don't know, maybe they're having a second meeting. We think that's what's going on.
No, I was gonna say, maybe if she
Cool.
transferred the host privileges to Frank or me, she might be able to
For this one,
leave
yeah.
and then start the other one.
I got you, yeah. Well, chaos has a nice advantage to it in its own way.
It's always a good idea to have a backup host anyway, in case someone is ill or their Wi-Fi goes out. It's a good idea to have two hosts.
Did the other one have a whole thing for us just to join with?
Oh, she just did that. She just transferred the host to me. So let's see if that works.
Okay,
You want me to?
so I'm going to drop off and try the other space. Bye.
Bye.
Bye-bye.
There should be a hang up symbol on the bottom of your screen that you can click on, David.
Oh, I have to do that first?
Yeah, you have to do that first.
Oh, same meeting?
The
All right, I'm
No,
leaving.
you leave this meeting and go back to the other one.
I was having trouble getting into the other one. Has everyone left?
They're still having trouble getting into the other one. There was an issue with host.
Hi, I had you all on mute. Sorry if anyone was calling me. I didn't hear you. So Ashley, we're setting you up
Right
as
here?
host for this meeting to
Is this
see.
the
if-
executive session or not?
No, this is the regular meeting.
Sorry again. I don't know why.
That works.
Um,
I'm sorry, Amber, I couldn't get in. It said the host had another meeting. So I am here too. So should I try it a third time?
What's happening is because I'm the host of this meeting, it's not allowing me to host two. So Robin's trying to see if she can set up a separate meeting, and I'm trying to see if it will work if Ashley is the host.
yeah, so you already transferred the host to me. You may need to log in and start the other meeting.
I see. So I'm
So
gonna log out. of
You're gonna
this.
have to leave this one, go
Okay.
start the other meeting, and then it should
I'll do
work.
that. Okay. Okay. Thank you.
Hello?
That's the one
Yeah.
that you're, okay. That's not gonna let you in, just turn it off. Go back to, you just, it seems like, go back to
You made it, Dave.
This one, actually, I'm noticing up on top, it is recording. You see, it says so.
Yeah, I think it has to. So, you know, when if you've ever watched on YouTube other meetings, it will just have a title page that says they're in executive session, but it's going on.
No, but this would be recording for the meeting, for the 12 minutes we talked about.
Yeah.
All righty. That doesn't look like Frank. Oh, Frank.
Okay, we are reconvening the regular meeting of the regular February 4th meeting of the Zoning Board of Appeals. We did not take any votes in executive session. Okay, so public hearings. First public hearing is 360A Mount Pleasant Avenue. Application number, we don't have the application numbers on these agendas. Amber, for the future, there should be, each of these should have an application number, and usually we refer to that so that we know that everybody knows where we are. I didn't notice until now that those aren't there. So next time, please make sure to have that on the agenda.
It's 6SP 2017.
So,
Dave just provided the application.
okay, so public hearing, is the applicant here?
This is 360A Mount Pleasant Avenue.
Yes. 360A Mount Pleasant Avenue.
Hi,
Hello?
hello.
Yeah, I just don't see the video.
Can you see us?
I can see you guys, and my screen says, video is running, then it says stop video, but I'm not gonna hit that.
We don't see you, so if that helps or doesn't help, it's,
Well, I don't, yeah, it's not showing up myself either, but I can see everybody.
okay. You can I mean, if we can't see, it would be better if we could see, everybody could see you,
No,
but
I understand, I just don't, my screen is highlighted, it's unmuted. Let me see something.
Sometimes it says start video on the top.
Yeah, no, mine only says stop video.
that implies it started.
Are you,
You don't look well then.
the camera
Is your-
covered?
No, is the camera the right camera? In other words, are you
Yes.
using an internal camera versus an external
No,
camera?
it's internal on my laptop, just like last time.
And
Okay.
it's
Video
uncovered? You
setting,
don't have
let me
any
just try
cover on?
something here. Video, FaceTime video, built-in camera, boom.
Is the cover closed?
No,
I was
No,
gonna,
like mine has like a little slide thing.
no. I don't see that, it's, for some reason, it's not activating. I don't see
Okay.
the green light, but everything is here like it's supposed to be activated.
Do you want to try leaving and coming back?
I mean, if you need us to share your screen, I can share your materials via share screen. Otherwise, Is it?
I mean, do you need the video? I mean, I can hear everybody.
I think unless council has a reason why we can't, I think we can proceed as is.
Yeah, there's no issue that I have.
Okay, so then go ahead.
Okay, well, basically, I think we were asked to come back here because you were basically approving that, the permit, to give us that special permit, but you had a question on the parking. And I think you guys were supposed to look into that. Now, I kind of did, and I believe this store is in a C2 zone, which is commercial, a commercial central zone. And from what I've understand is that you do not need the street parking in a commercial central zone. Hello?
Yeah, we're
That's
here.
that's a good
Okay.
point.
That's what everybody's looking at. So, I mean, I think everybody's
I
checking
think
that
we all
out
assumed
right
you
now.
were in the C1. I was assuming he was in the C1 and was not noting that.
No, if I'm not mistaken, I pulled it up. I pulled up the rule.
Yeah, that's a
And
very
I
good.
believe I went through my old paperwork. This is a renewal.
Two district.
It was a renewal. So the original paperwork stated the same thing because we had the original file. This
And
is
if you-
after the Zoom call last month. I looked into it. And, it stated that it was in the central commercial zone. And I guess the off-premise, off-street parking doesn't apply to
Hmm.
these, delis and places with food preparation in the central district zone. Because none of the other stores have it. Sage Deli, anywhere else you see, anywhere around here, nobody has off-street parking.
Yeah.
Funny because the winery that's around the corner, that was definitely C1. So it must be right where the boundary line is on the zoning.
Well,
map.
Robin.
So Frank, is that correct? Is this correct? It's in the C2? Someone?
Frank, are you there? You're muted, Frank, if you're saying
Yes,
something.
it is a C2. I'm sorry, I was muted.
Okay, so if it's a C2 and parking isn't required, then we're
And that
done.
explains why there was no history about it. So it's great. And we can proceed with considering for the renewal of the special permit. And
Well,
I
we
think
can-
we already did quite a bit of
we can-
discussion last time.
I think if that's correct, then we can proceed with if anybody else has any other questions or if any members of the public. So before I go to the public, does anybody else on the board have any questions? Okay, does anybody from the public wish to address this application? Amber, I'm taking no, you're not seeing anything?
I do not see anyone who wishes to speak.
Okay, so then is there a motion to close this application?
Second.
Okay, Greta,
Yes.
Abby,
Yes.
Meg,
Yes.
Dave.
Yeah.
Okay, and I vote yes as well. This application is closed. So we may get to discuss this application tonight. We may not, depending on time. In which case we'll discuss it. We'll, have a resolution next week.
Okay, thank you very much.
Next month.
Thank
Next
you.
month.
Bye-bye.
The next item is, and I'm going to try and get the application number 1043 West Boston Post Road. Does someone have do we have the application number? I don't have it in front of me.
Yes, 1 second, sorry. Looking, there's some, a lot of papers.
And the way I got the application summary, I got the application summary sheet.
Oh, here it is. It must be on the next.
21, 1035. I'm sorry.
This application,
Mr. Spatz has sent it in the chat. He sent the number, he sent the application number in the chat.
Oh, it's not written on there.
Apparently it's 1 SP 2021, is
Yeah,
that it?
sorry, wait.
Yeah, 1 SP 2021. There's the application. Okay, so 1 SP 2021, 1043 West Boston Post Road. So, Mr. Spatz, are you there? I know you're there because you sent that chat, but there you are.
Good evening, everyone. Chair,
Hello.
members of the Zoning Board of Appeals. Amber, do we want to go through elevating the presenters? We have a few.
Will do.
Thank you very much. And while our distinguished village planner does that, I'll just introduce who will be joining us this evening. And by the way, Chair, if we figure out what indeed that picture is behind your shoulder, do we get a free special permit, or I'm just kidding.
No, it's, look, I'd be interested to
I'm
know.
trying,
And
I'm
I'll ask
looking,
my
I'm
husband if he
trying
has
to
any
figure it
idea.
out. I don't know. Okay, so we have Nick Marsh joining us. He's the CEO of Founders Table of Chopped. We have Colin McCabe, co-founder. Tom Kellner, COO. Dennis Lee, he's VP of Development. Amanda Ehrlich, Design Manager. Justin Gould Senior Manager of Construction. We have Brian Dempsey, Traffic Engineer. Ralph Paragon, he's the Civil Engineer. David Steyer, who is our landlord. And Kristen Wilson, who is co-counseling with me this evening. So I just want to make sure everybody is on.
Not everyone's names that you just listed appear here. So if you are one of those people, please raise your hand so that I can promote you.
If you're missing.
And Chair, are we following the same order of decision-making on this application? Are we first looking at the interpretation of the window, outdoor counter, drive-through, whatever it is? Is that what we're concentrating on first, and then we'll get to the special permit?
Yes, because we have to decide whether or not they're a use that we can approve. In other words, whether it's a permitted use, in which case they can have a special permit. Otherwise, if we determine that it's not a permitted use as of right, then they would need a variance, or they would need to amend their special permit to take out the window. Whatever one calls the window, we'll leave it as the window. There is a window, it's a window. So yes, so the question now is we're still trying to determine whether or not the use of the window, which is the only issue, is legal. For whatever reason, whether or not the use of that window is a permitted use, in which case we can proceed to the special permit, if it is.
Great. So I just want to make sure everybody on my team present and accounted for. I'm gonna have to use like 3 different monitors. That's how many people we have on here. So, okay, I just want to make sure we're ready to
Yeah,
roll.
Colin, I think you listed Colin. I don't think.
Colin, you on?
Colin could not attend tonight.
Okay,
He won't be.
okay, got it. Just want to make sure. And David, are you on? Dave, there you are. Okay, great. I think we're ready to roll. And before, I would be remiss if I didn't welcome back Dave Newfield. It's good to see you. It's like the team's back together again on ZBA. My name's Andrew Spatz, for the record, 650 Halsted Avenue, Suite 105, here at the Village of Mamaroneck for the applicant. And at the conclusion of our last appearance before the Zoning Board of Appeals, it was suggested and it was profoundly accepted by the applicant to proceed with some discovery and due diligence with regards to seeking out case law and utilizing the case law previously made reference to and sharing that, as well as providing some industry standards with regards to our position. And I'm hoping that everyone had a chance to review the legal analysis that Ms. Wilson and I filed with the village. And I'm certain when you look at this, you'll see that this was not merely an academic exercise. We really took your input. We wanted to explore the concerns that you as members of the zoning board had. And ironically, one of the biggest concerns that appeared prevalent in the last presentation was the need or the possibility of changing laws that don't exist. And again, having been trying to do this for 5 years with the Industrial Advisory Committee merely to do an overlay, I understand challenges that can be. But through the due diligence that Ms. Wilson and I embarked upon by reviewing our code here in the village, we actually have the existing language that merely begs and requests the interpretation. And just taking a step back, obviously, what we discussed on our last appearance was the demands of the industry as a whole are requiring restaurants to increase accessibility of their meals and arriving at an innovative and contactless means to do so. And one of the questions that was had was, well, what are the industry standards? What are the definitions? And we provided the Institute for Traffic Engineers, ITE, provides several definitions that were provided to you regarding the different types of restaurants. And CHOP does not fall within the definition of a fast food restaurant. That was one of the major concerns during the last presentation. This is by industry standard and by our own village code. It doesn't fit that criteria. As the primary goal with fast food is how fast can it come out? How fast can someone get the food? Rather, the focus of CHOP is to prepare a customized made to order salads or wraps to patrons. Now, breaking down the village's definition of restaurant, CHOP is a business engaged in preparing and selling food to its patrons. Now, the only portion of restaurant that's not in the definition and that's not met is the threshold of patrons being served by waitstaff. Now, when a patron comes to CHOP, as they would here on Boston Post Road, they would enter the restaurant and they would select their food and watch their custom-made salad being prepared. Now, if the patron wants to stay and dine in, they'll do so, and CHOP employees will provide them with these reusable dishes and flatware. If the patron decides to take the food to go, the meal will be made, again, made to order. It's not prepackaged. And there's absolutely nothing prepared ahead of time, and the entree is created only after the order is made. And by standards being the industry standards, CHOP is defined as, quote, fast casual restaurant because its price point is way higher than fast food. Average is $12. The preparation time is way too long for fast food. And the advertising and promotion of its business is not, it's different. It's a bit different model. It's not, again, based upon speed. And most importantly, the food's not frozen or prepackaged. Now, CHOP's model, according to the village's definition, it also would not fall under fast food. Specifically, when an individual is dining inside, a patron is being served in reusable dishes and flatware that's washed and again reused in the same fashion as any other restaurant. Furthermore, the food is not typically eaten by hand and is not handed to customers in pre-packaged material. Finally, they're not multiple counters from which one can order, for example, pizza slices, fries, or chicken nuggets. To further illustrate how CHOP may be distinguished from traditional fast food or other restaurant definitions in our code, 90% of CHOP's patrons customize their orders, 90%. Although CHOP does have a pre-designated menu board from which patrons can choose from, 9 out of 10 patrons choose to specialize their entree. Now, as an integral and essential component of this application, CHOP is also seeking a special permit for car service, which is defined as, quote, service from a restaurant provided to customers remaining in their vehicles and parked in a designated parking area of a restaurant parking lot. The car service component falls squarely within the village's intent and purpose for allowing car service and serves as an essential component for CHOP's operation and financial viability.
I'm sorry, I don't see that in the application, the application for the special permit for the car service.
Well, what we're referring to, Meg, is the interpretation. Last time we made reference to it as a window. And in this situation, what we're seeking is we're now seeking the interpretation that this would actually be used as a car service.
I was
Now,
gonna
again, but
ask
if-
if this is, if you're changing what you're asking for, does it have to be re-noticed? If you're asking for a special permit for car service now, and that was not what you had noticed the application for.
Actually, the memo that they've submitted to us, Meg, says that they're going to amend. They would like to amend to include it.
So does that need to be re-noticed if they're amending?
No, it shouldn't need to. It's a special permit because they're getting a special permit anyway. Usually it's for a food service establishment is what the special permit is for.
But this is for a specific accessory use to it. And it
That's actually, Meg, that is actually the car service is defined as what I just read, and that's incorporated in the actual definition.
when I read the definition, it said that restaurants are eligible to apply for a special permit for car service. It isn't automatically assumed that if you're a restaurant. And
Or-
special. I'm sorry, if I misread that, it said restaurants are eligible to apply for special permits for car service. They're the only type of food establishments that are. But it is, you have to apply for that additional special permit is how I read the code. Perhaps I read it wrong.
Well, to operate, obviously, to operate a restaurant, a business that's engaged in the preparation and sale of food and beverages selected by patrons requires a special use permit, as does if you're seeking car service shall also be permitted by special use. I'm sorry, by special
By
permit.
special use. So I read that to be
Special permit.
not automatic when you get a restaurant. You have to notice it. The public would have to know that you've requested car service special permit. That
Ms.
is
Jurgen, I will say this,
up in the one.
ultimately, if we all end up at the finish line where that's the only component missing and we're all in the same agreement that, hey, when I say agreement, meaning that zoning board of appeals feels that, okay, we do fit, if you even interpret it, we do fit in that category. That's something that my clients would be more than happy. If council and the village planner feels that something has to be done, then we'll do it. But if I may, I'm kind of concluding the whole correlation of the car service and the restaurant interpretation here, why we would fit within that. At the end, we can decide that. But again, if that's the little component, I mean, that's for us, that's fantastic. So
You've amended the I just want to be clear. You've amended the application. You're not going to ask for a use permit. I mean, we're still.
No, we're not asking.
Wait,
for-
but can I
I
ask?
want to know I want to know what we're trying to decide. You're still asking us to interpret the code. You're still asking for that interpretation, that you still have an appeal for the interpretation.
Yes.
You're also going to ask for a special permit for the restaurant. And as a part of that, you're going to ask for a special permit for car service.
Ms. Jurgen,
True. And
Could
I still
somebody
want to bring it.
explain- Could somebody tell me where, because I don't remember seeing, oh, I see, never mind, go ahead, sorry, go ahead.
So I just want to say, bring us back. I thought we were going to go through
We
whether
are.
the interpretation of the window, and then we can talk about car service or whether you need to renotice or not, but we're kind of getting off track of sticking to the original interpretation that you requested.
Well, I think that's right. I mean, what Meg says is a summary. That's exactly what we've said. But I think if the applicant wishes to talk about, to present the whole thing, we let our applicants generally talk broadly. We're not going to be discussing that when we discuss it now.
Okay, I thought we had.
Because it's part of his application. I mean,
I
it's
thought
not
last time
discussing
we
the
had
findings.
asked- Okay.
He's not discussing the findings. He's just sort of discussing overall what they're providing. I think
Go ahead.
it's fine to give that impression of overall what they're providing. We're not discussing findings or anything about that. If he thinks that the car service issue is relevant to helping us understand why the use of the window is okay, then I don't think we can tell him it can't you do that.
that's, in essence, Sheriff, that's exactly where we're going, because in the next paragraph or two, I'll go there. And I know Ms. Wilson will also be able to provide parallel cases and whatnot, which would fit our criteria. So where I was indicating about the fact that the car service component falls squarely within village's intent and purpose for allowing car service and serves as an essential component for the applicant. As previously communicated, the patrons that are opting for the car service will have already ordered and paid for their meal off-site. We discussed this during the last meeting. It will require less than 30 seconds to pick up their food, thereby avoiding any lengthy duration on site for this car service. So it would be actually a very efficient car service. Moreover, those patrons who are opting to use the car service would be given a designated pickup time so that they are not waiting for their food to be prepared for any length of period of time. After the meal is ordered remotely and a pickup time is provided, CHOP subsequently texts its patrons that the food is ready so they can, again, so they don't drive up early. Additionally, and this is something I don't know if we spoke of last time, but I think this is an important component. To avoid any possible congestion, CHOP limits number of pickup orders in a 15-minute window. So, for example, let's say it's 10. Once that 10 orders are hit, that's it. You get pushed to the next 15-minute slot. So there's a predetermined cap to ensure sufficient time to prepare orders and to have seamless pickup. Importantly, the car service lane, or if you want to refer to it as the car service stall, will not impair the circulation of vehicles and pedestrians on site and requires a patron to immediately exit the site on Boston Post Road. There was discussion at the last meeting in terms of, well, what happens after somebody picks it up? Can they pull around and stay on the lot and eat? That's not the case here. It directs you directly back onto Boston Post Road. It's interesting to note that car service is an accessory use to restaurant. The matter of Sirota Smithtown LLC versus Town of Smithtown Board of Appeals, Second Department 2014 decision indicated that the court did not disturb a finding where curb service was an accessory use to a restaurant. We did provide that case in our package. There's absolutely adequate on-site parking, proven on-site traffic circulation with previous drive-through. This was, again, a bank previously with a more high-intense use, actually, as a bank and drive-through services. And I'm going to conclude my part of the presentation by indicating the fact that at this point, there's been no evidence on the record that our application would have any impacts to the health, safety, welfare, or comfort of surrounding properties or to the order of the village that would be created by the incident application. So I kind of gave a brief overlay and outline of that very extensive legal analysis that was filed and prepared. And I think at this point, Kristen and I will, and the entire CHOP team are here to answer questions and concerns with regards to the legal analysis that was filed and what was shared before. Thank you.
Anybody on the board want to ask questions about questions of the applicant on the issue of interpretation? To me, just as the first, to me, the issue is, I think you've missed it all. I think you've missed the questions completely. To me, the question of what this is, we know it's not drive-in. We know it's not drive-through. That's not what this is, what the window is. I don't know what the window is, but it certainly isn't, to me, it isn't any of those things. The most it is some kind of a counter service. And we start with the beginning thing of what is this thing that you're providing? I don't know what it is. If we took a strict interpretation of our code, I'm not sure you'd be permitted, but we all know that the restaurant definitions in our code are less than, I don't know if intelligible is the right word, but less than clear, and they smush together. You know, food service establishments can't have car service, but restaurants, which are food service establishments, can have car service. So clearly there's all kinds of inconsistencies among the definitions. But to me, I'm not sure what this is. I still don't understand. That's my piece. David, Meg, you look like you wanted to ask some things.
Yeah, I've taken a look at this thing. I mean, I looked at your submissions and you indicate, you know, you're operating you call it I guess a fast casual dining establishment, whatever it is. But it is a food service establishment. Indeed, if it wasn't, you wouldn't even be able to get the car service special permit. But what I don't understand in the interpretation is, and maybe I'm missing this, but I don't know what there is to interpret, because an interpretation requires an ambiguity, not we're going to change the law. And in this case, you've actually, in your papers, you acknowledge that the literal reading of 342.25 would prohibit the use of the contactless and the pickups using the window. And it's a food service establishment. And the Board of Trustees has determined, for good or for bad or indifferent, that it is verboten. It is not permitted. So I'm not sure how, I'm not talking about a variance issue, but in terms of an interpretation, it says, ye shall not have that. And that's what it says.
But David, I think the question is, what is it that they shall not have?
An
And it's the
open,
issue.
what they
An
describe. in
outdoor counter. An outdoor counter.
342.25, an open window counter. I don't, unfortunately.
That's not what it
for-
says.
The
That's
text
not what
says- the
45 says, and that's where the interpretation.
No, the
comes in.
text says outdoor counter, so for me, that's black and white. It-
Correct, and that may be right. And that may be right, and that's the interpretation. They are saying it's something else.
No, but they're not. They're saying that the literal reading, it's right in his papers, actually. The literal reading and interpretation of section 342.25 would prohibit. That's, I'll get you the page number, but it's right in there. And it is
That
an outdoor window. I mean,
In that
I don't
case, I think I would agree that there's no interpretation. If you think that it's, I thought the issue as we discussed it last time was whether it was any of outdoor counter, drive-in, I don't have 342.45 in front of me, whether it was outdoor counter, drive-in, or drive-in. And the discussion was it either of those things? And that's what you were sending us the interpretation. If in your memo, and you said, as Dave says, that it isn't, then I think we're done with the interpretation.
I unfortunately, I don't know if Mr. Newfield had the chance to review the entire hearing that we had on the last appearance, but we went through the litany of why we don't fit any of the definitions. It's whether or not it's
You fit the
restaurant.
definition of
Is it
food
your,
establishment.
is it your position that you're not a food service establishment?
The closest thing that we match is restaurant. We're not fast food. We're not carry out. We're not a brew pub. So we have.
But are you a food service establishment?
We're a restaurant, Mr.
I
Newfield.
asked you that. The word food service establishment is defined in Article 342-3, Article 2, Section 342.3. It says, any use which includes the serving of food and or beverages that requires an eating place permit or is otherwise required by either county or state law to be licensed, including but not limited to restaurants, carry-out restaurants, delicatessens, and fast food restaurants. That's
Right.
that's
So
the
if-
definition. I mean,
We are-
your papers that you submitted say you're gonna operate a certain type of restaurant. I mean, I don't want to quibble with you. I'm the same, but you serve somehow food. You're within that. I think the phrase food service establishment was a penumbra. It was to say everything fits within it. And that's the phrase that's used. Isn't the phrase, I don't have 342.45 directly in front of me. I'll have it.
Obviously, we are a food service establishment.
There you go.
But by virtue of our code, fast casual is not defined. The
Right.
closest thing to our use is a restaurant. Hence, that gives rise to the ability to incorporate a car service. Now,
Okay, but we're not,
No, but go to-
but as Meg said before, the issue of car service has nothing to do with the issue of the interpretation. If your special permit includes the car service, okay, when we consider the special permit, we will consider the car service question. The issue before us now is that window.
So
Is it a counter window? Is it a drive-in? Is it a drive-through? If it is something that is prohibited by the code, which is what we'd understood the question was last time, and that's the question, that's the
if we don't-
interpretation question.
we don't.
That
feel-
Robert, if I
window.
could, 342.45, just to pick up on the last definition, says no food service establishment, which is defined earlier, as we said, at 342.3, okay? And it's shall provide outdoor counter, drive-in or curb service. And it goes on. And that's exactly what you say, if we follow that literally. And candidly, I mean, I'm at a little bit of a loss to understand how I read that.
Okay, so when we went,
And I appreciate, I think you're very forthright and direct and honest in saying, yeah, literally you do. Well, literally is what it is. I mean, what do we say? Except if it's blue or except if it's this?
Mr. Newfield, what we did and what we tried to distinguish on the last appearance was that the fact that this is a service window in a sense that it's not an outdoor counter, drive-in or curb service as defined historically. If
It's
you
not
go
defined.
and you find the definitions, Mr. Newfield, we don't fit any of these. Case law was very clear on the drive-through And the counter.
Not drive-in service?
In your memorandum, can you tell us where you discussed outdoor counter? I found a lot about
Yeah.
counter service and drive-in and drive-through. I did not see where you were describing what an outdoor counter is, that it's not what we're thinking of. It's a counter that leads to the outdoors.
We don't.
It would be an outdoor counter.
The counter's exterior. This, a window, if it's flush against the building, there's no counter.
Except
It's
that
not a-
we've had precedent of calling outdoor counters in other places where there's the person serving on the inside and the customers on the
But
outside.
the
And
courts define that using intercom, electronic devices to order that, to pay for it, and to wait on site. We don't fit any of those categories though.
But why does the
Outdoor
fact
counter has
that
nothing to do
you,
with how you're
that
getting
you order
food.
electronically not make this a counter? It is a counter. Food is being provided to you from the inside to the outside through this counter. Ergo, it is, and the counter is half on the outside presumably. Or
But the aesthetics, and I don't know, I mean, are you looking at a visual architecture rendering what it's?
no, but the point that is the mere fact that you order electronically and not at the window or not on a menu board isn't what tells you that this is an outdoor counter or
But-
not an outdoor counter. I don't think that's the definition. There's nothing in the definition. that-
What
It
makes
doesn't
it?
have, the restriction
What
is,
makes it? What makes it then? What makes it a counter? If
the
there's no
restriction is
exterior,
not
what makes it
just
a counter?
against the restriction is not just against outdoor counters. It says outdoor counter, comma, drive-in or curb service.
Yes,
And
but we,
Mr.
but
wait,
David, we know that this is not drive-in or curb service. There's
But
no
it's not,
question this
it's
isn't
not curb
drive-in or
service
curb
and it's not
service.
It's
drive-in.
not drive-in?
That's not the issue. The issue that may be is the counter.
Okay.
But if you don't have an exterior counter, it's not a counter. How can it be defined as a counter if it's not exterior, if there's no counter? It's a window.
I'm sorry, isn't there a win? Somehow, somebody on the outside has to get the food, correct?
If you hand it, there's no counter. I mean, we can get real, we can.
Okay, that's your argument, is that
That's
the
right.
counter is so small or such a little
We
lip.
don't need a window, Ms.
Counter
Yergin.
count.
That's not part, you see, nowhere in my definition.
In other applications, we've talked about Walter's Hot Dog as an outdoor counter. It's grandfathered in. We talked about Ralph's having an outdoor counter. Those are walk up. Nobody talked about how big is the counter or not. Is it big
But there
enough
is
to
no
get
counter.
counted? It was considered an outdoor counter because customers were
So-
getting their order through a window and they're.
Which leads us to.
I guess that's what we kind of have to interpret, how we interpret outdoor.
This is incredibly ambiguous, which leads us to the fact that when the code is ambiguous, it falls to my client's benefit. There's case law on that states that in a situation like this, where we don't know what you guys don't even know what it is. So in this sense,
So can I
have
take it?
problems with knowing what it is. You're the one arguing it's something different.
and we are, we're saying Meg, again, you made reference to Ralph's. You made reference to.
And Walters.
The hot dog. Hey, I got it. But that's none of those models fit the definition of what.
I'm talking about it in terms of this, for what the definition is of an outdoor counter, a customer on the outside and the business transferring something through the window over something that's called a counter has been called a outdoor counter in other applications.
There is no counter here though.
So if I can take a step back for a second, I think what we tried to do after the last meeting was go back, see what the industry standards were, see what Wikipedia, what Black's Law Dictionary, what the standard definitions, the common definitions of restaurant and drive-in and counter service are. We provided you everything we could find on that. And then we did the next step. We took the next step, look at your code and see exactly where we best fit. And yes, we think we fit most clearly as a restaurant, a subset of a food service establishment, but we're actually a restaurant. I don't think that is incredibly debatable at this point. We provide service to patrons. We have an indoor seating area. Customers can choose to order inside or electronically. And then lo and behold, your own code says car service. Here,
Wait, I'm sorry to interrupt you, but why is that relevant to the question of whether or not this is
Right.
outdoor counter? The fact that you are a restaurant, whether you're a restaurant or some other kind of food service establishment, doesn't change the issue of what this thing is.
So if I,
per
right, so
restaurant.
this thing that we're trying to best find a home for our use is when, as you go through each and every definition in your code, as part of the restaurant definition, the last sentence says car service is permitted by special use permit.
Yes,
So, okay, what is car service? You have a definition of that. You know what? After looking at all the different types of food service establishments and various ways to get food in customers' hands, this actually fits really well. It fits the best. You're delivering, instead of someone having to open the door, walk 5 feet into the restaurant to pick up their food, it's handed through a window.
You're
And
absolutely,
I'm sorry, and per Webster, outdoor counter, per Webster, outdoor counter, I think Ralph, who actually just even, it's defined as a level service such as a table, shelf, or display case of which transactions are conducted or food is served or on which goods are displayed or work is conducted. We're not proposing any of that. We never have, and we never would propose that. That
I'm
is
sorry.
counter service.
You're going to have some sort of shelf and you are going to do some sort of transactions over it. So
But
I
Meg,
disagree.
that doesn't, transaction is not defined by counter. That's not part of the definition.
Whatever you were just
Code?
describing, it was talking about some activity over a shelf.
But that's not, but our code doesn't, Meg. Our code, I'm sorry.
No, I'm sorry, you just twisting things around. Our code
I'm
says
not
outdoor
twisting things
counter.
around.
I'm sorry, just let me finish. We're discussing outdoor counter and you found a definition of outdoor counter, so I'm discussing what you found in Wikipedia. I know the code doesn't say
Not
it.
Wikipedia.
You're using it
That's
as trying to defend your argument that the outdoor counter is not an outdoor counter. That's the only reason why I went to your definition.
I also just want to add that the Chopped, which I love, does not meet the definition of restaurant. A material component of the definition is waiter service. That's critical. You don't need it. You're not a restaurant. It doesn't matter what ITE has Chopped as. What matters is what the code says, and you don't meet the definition. Critical component of the definition.
Greta, no, we don't match any of them that the village provides. That's why Chipotle and dozens of other applicants have come in as fast casual that don't fit in the 4 criteria. That's why Greg Cutler was trying 2 years ago to have the board revisit this.
Right, but
Excuse me,
they
don't-
all are under the
Oh.
umbrella of food establishment, and that's where the prohibition
that's it.
we're asking about. So
But
it does,
there's-
it's a moot point when it gets to interpreting outdoor counter or cars or the drive-in or drive-through. It doesn't matter whether there's a category that fits you or not. You're under the umbrella of food establishment.
Right, but we're also.
Do you
on-
acknowledge, do you
if we're-
acknowledge, Mrs.
Whoa,
Scott,
Whoa, let's
you
do one at a
acknowledge you're
time.
food service establishment?
And Andrew, go ahead. What were you saying, Mr.
No, go ahead. I'm sorry. Thank you, Chair.
David, were you
I
wanting to say
just want
something?
to understand one thing. You keep arguing and quibbling with this restaurant concept and fast food restaurant, but you're a food service establishment, correct?
We, of course, you
Thank
have to be.
Thank you. And you refer to yourself as a restaurant, but it's the food service establishment that the prohibition applies to.
But-
Whether you
but
want to call it
Mr.
drive-in,
Newfield-
excuse me, and I think the car service that you referred to, that's the means by which things are picked up. As the chair correctly said, you can go in the front door and open the door and walk in using the car service. You can also take a train and walk over, but that's your business. This is saying the trustees have said, but you can't use a window for drive-in, for counter, for whatever you want to use it. I don't know. To me, it's about as, I don't know how else, and I don't know how else I would write it without making every piece of legislation an event that would go on with linguistics and for weeks. I mean, they said there'll be no counter service, no drive-in, no pickup service there. All right, fine, that's all. And they applied it to food service establishments, not the restaurants, not the fast food, but to the penumbra, the whole thing. I'll be candid with you. I don't follow how we even have jurisdiction or authority to say, well, we can just look the other way on that, because I think they were very clear. I'm not saying I agree or disagree with them, but it's just not our call. That's how I see it.
Our
But-
call is simply to decide whether or not we think this is something called counter service. With respect to car service, I don't actually think that driving up to a counter is car service because it's not a designated parking spot. So to the extent that you were trying to say that this window could be interpreted to be car service, it isn't a designated parking spot. You're
We
not
would make it
parking
that.
there. You are in a, what?
We would make it that. We would propose as part of our site plan that would be the designated car service spot. We time things so that orders are picked up every 15 minutes or whatever the normal business model is for Chopped. So there's no queuing of traffic. It's not a typical drive-through or
that-
anything.
Is that
So then
limited? Yeah.
somebody would be, so in other words, you have this counter, if I'm trying to understand what you're saying, you have a counter, right? Or you have something, we won't call it a counter for right now.
Window.
We have this thing, this opening in the physical wall of the premises.
Fair enough.
And in front of this opening, there will be a parking spot. And you
Yes.
are saying that you drive up, park your car in the parking spot for 15 minutes. And while you are parked in the parking spot for 15 minutes or something else, that someone will give you your food through the,
Vestibule.
what I call it, opening. Correct? Is that what you're saying? As why you're saying this is car service essentially?
Correct. A patron would come within their 15-minute window. Hopefully, they're not waiting there 15 minutes, but nonetheless, they stop, they park their car, they wait for their food to be delivered. It's a convenience not to have to open the door and walk in. They could do that if they wanted to go and park, but that is where the car service, this is where it most neatly fits. So
But
we are
unfortunately-
suggesting to you that in
unfortunately,
lieu
now I
of a
understand the
pickup
argument.
window or counter,
But
this
but
is more-
unfortunately, since the outdoor counter is prohibited, you could not operate the car service that way. I know that Applebee's used to, when it was open, had car service. You would go and you would call and say, I'm here, and somebody walks outside and gives you, there's another,
So
I'm
actually,
sorry,
that's
there's another way of delivering the food to the car.
Wait,
And
that's a
since
good point.
excuse me, just let me finish. Since outdoor counters are prohibited, yes, even if you got car service, it would have to be parked in a space and someone would have to deliver the food in some other manner because you're not allowed to do it over an outdoor counter. Simply because you're calling it car service doesn't all of a sudden make outdoor counters legal when they're expressly prohibited. You
Meg,
could
so
park
that's
it
a good
if
point.
you
Meg, that's a
got
good
by
point.
special permit, you could park your car. People could walk outside who work in the restaurant and give you your food in it, but you are not allowed to do it over an outdoor counter.
That's a good point. So if we put a door and we have this car service stall designated and someone just walks out the door and brings it to the car, boom. You're
You would
right.
have to consider that, I guess.
I
But
completely agree with you.
the setup that you're asking for is not what you're just.
But if we had a door, exactly. I was here too when Applebee's did it too. I remember exactly where, Sedona is now. And it's exactly the concept with a door where somebody went out and brought it to you. So if you had a door and they brought it in that stall, we would absolutely fit within the criteria. That would be exactly this. We're asking somewhat of an interpretation, but without that vestibule or the exterior window or the window, someone going out the door and bringing it in that stall, boom.
Would the car service be limited?
And we would satisfy the car service component of it.
Could anybody use a car and go to that same opening or not?
No, you have to have your order, Mr. Newfield. Absolutely.
No, but let's say a person owning a car who wants to serve the food to their family, they order it, could they go?
No, it's again, with what was reflected in the analysis in the application, you have to order in advance.
We've ordered.
Right.
Right.
And then if you have order number 50
Right.
and you were supposed to come at 8:45 tonight, you can go drive your car, park in the designated car service stall, and you would probably text whoever's inside. I don't know exactly how the mechanics work. Say order number 50 is ready, or the patron is here, then 50 is delivered their package of salads.
See, I don't have any questions.
There's no window at all.
But I found one thing. I found where I seen this. It was in the second page of your narrative. third page of your narrative, where it says the literal reading and interpretation of section 342.45, which is the prohibition, would
Excuse me, can you
prohibit,
tell us where you're reading from? I'm sorry, just so we
Yeah.
can follow. Where you're reading from?
starts the top of the page, the literal reading and interpretation of section 342.45, it's very short, would prohibit the wide use of contactless pickups from windows or existing establishments and or outside pickups, et cetera, et cetera. My point is, you're right. I agree with that. I don't know how there is anything to interpret based upon that. You've even said the interpretation and the literal language, and it is. And it's not a question of agreeing or disagreeing with you, but if it's a horse, it's a horse. And that's what it is. It is, to me anyway, you know, it's my view of it. It's about as clear as you could be. And they said, thou shalt not. And we can, I don't know. Okay. You understand my point.
So if we approach this from if it's the physical counter, that's the prohibition, the prohibited point or part of this application. If we did create a door and we did on our site plan clearly mark this as the car service space or area or spot, and someone, instead of putting their arm through a window, stepped out of a door and took 1 or 2 steps to the driver's side door, are we in agreement that that is car service and that is permitted by special permit?
We are in agreement. The problem would be whether or not we consider you to be a traditional sit-down restaurant by the definition, because only a restaurant that has table service and where the majority of the operation is wait service and people eat their food on the premises qualifies to be a restaurant, because that's the only type of food establishment that then can have the car service. And you're arguing, since you're not fast food, that you must be the restaurant, but I don't buy that argument. We've always held that table service is an integral part to consider a food establishment a traditional restaurant. And we're all very aware that our code is lacking the newer versions of restaurants, but because you're not one thing doesn't make you another thing. It makes you a food establishment. And that's how we've handled it with all the other iterations that didn't seem to fit things in the code. We definitely gave special permits for food establishments and we called them different things, but we never had thought that we had to pick, you're either a sit-down restaurant or you're a fast food. We have allowed other iterations to go there, but it didn't all of a sudden, anything that's not a fast food is not considered a restaurant. And I agree with Greta that an integral part, the essential part that defines a restaurant as opposed to a fast food is that, or anything else that we've in the village, is that it has table service. It's like a first sentence in the description. It has table service, and then you eat your food on the premises.
I think Meg has said it very clearly, I think, how we would understand this. Everything is a food service establishment. There are subcategories which are specifically defined: restaurant, brew pub, fast food, whatever else there are. Everything else is just a generic food service establishment. And that's what you are, or that's what Chopped is, a food service establishment, subject to the special permit requirements for food service establishment, car service limited to restaurants. I think that's right.
So Sheriff,
Can I ask a couple questions? This is Nick, to the board. Chairman Kramer, how are you? Nice to see everybody again. And I apologize if I'm out of order legally, but
No, you're fine. You're fine.
It's only slight. It's as painful for me as it is for you to hear the debate over what a counter is in the world. I appreciate your position, David. I appreciate your position. I mean, here's all I want to say. We have 20 years of being in business, of having a successful business, and trying to be pretty cooperative and working through everything from Times Square to, you know, a lot of different suburban environments we're in. I don't want to do anything that you guys don't want us to do. Okay, I would like to do something that you feel fits your code. My code too, because as we covered on the first board, I'm from America. But here's our business. Our business is that 60% of our customers are going to order food on their app or on a computer, and they're then going to drive to the restaurant to pick it up. And this particular location, and look, that creates a volume. We're a successful business. It can be a lot of people, right? And this particular location does not have the facility. It doesn't, like, it won't work. Like, we have to get the food to people somehow, right? So I assume, and I could be wrong in this assumption, that people would be allowed to drive up and park, and we could walk out the front door of the restaurant and bring them the food. That's what we do. We do that in 63 different locations right now, right? So if the issue is we can't handle, what seemed to us would be the most convenient is you pull up and we hang the food through the window, right? That would work very well. But if you don't want us to do that, we don't have to do that. What seemed next most convenient is if you pull up, we'll walk out the door. You know, we can walk out the door and hand you the food. I don't know if the issue is, does there need to not be one designated parking space? Are we not allowed to bring the food out of the restaurant and give it to you in your car at all? Is that like unless we can convince you that we're a restaurant, so now I gotta have table service? Like, I gotta get people the food. They want the food. Do we have to make them get out of their? The problem with making them get out of their car to come in the restaurant is they won't do that. If a woman is driving around, or a mom or dad is driving around with a kid in the back of the car, right? Like, they want us to be able to bring the food to them, so they don't have to come out of the car. So I'll do it however you want us to do it. Dave.
Let me ask you a question out of curiosity, trying to figure. Yeah, the problem is exactly as you said. If this is a restaurant, then you can have car service,
Right.
okay? You can have it as part of the special permit or separate,
Right.
whatever it is, you can have it. If you're not, if you look at the individual definitions.
Yep, I've been through them.
Right, most of them say you can't have car service,
Right.
okay? Restaurants say you can't. Now, however, question is food services, including food service establishment, which says no car drive up or car service shall be provided. So to the extent that you are this generic, and by generic, I don't mean you're like anyone else, I mean this sort of umbrella food service establishment, the overarching food service establishment, you can't have car service. The only place in our village code that allows car service is a restaurant. So if you don't fit within the definition of restaurant, which requires table service, you can't have car service.
And
does
does car service means any version of an employee walking out of the restaurant to give them their food?
It says
Can't do it.
definition is service from a restaurant provided to customers remaining in their vehicles and parked in a designated parking area of the restaurant parking lot. So you are somebody, yes. So the analysis and that Kristen, I think, was providing as to, you know, you'd have it designated and somebody only works if you're a restaurant in the first place, which is Meg or Dave, somebody said, sorry if I don't remember which one of you said it. Depends on you being a restaurant in the first place, because if you're not a restaurant and you're just a food service establishment, then the code specifically says you can't have that.
Wait, Chair, if I
hear you,
can,
Mr. Marsh.
34245, and I'm looking at it, and I mean, again, maybe I'm getting older and I'm certainly getting grayer, but okay, they talk outdoor counter, drive-in, curb service, curb. And we all agree, this is not curb. We're not looking at a curb. We don't, and again, we went, last time we really dove into drive-in. We don't feel we are drive-in, and I get it. Outdoor counter. I understand Meg, and I respect Meg and Dave's question about, okay, what is this? What are you going to define this? But I'm looking for no car service.
In the definition, in the definition of food service establishment in 342.3, it says any use which includes the serving of food or beverages, and it goes on. And then the last sentence is no drive up or car service shall be permitted. Now, why our code made this distinction, I couldn't begin to tell you. You probably know, you were probably working on it in 2008.
Wish I worked, Robin, we wouldn't have this problem.
But in any case, that's the problem. It's a fairly straightforward and simple problem. You only can have car service if you're a restaurant. You are not a restaurant because you don't have table service. Ergo, you're a food service establishment and no car service is permitted, and no counter service, and no whatever outdoor counter, and no these other things.
But let me ask you this question. At Chopped, if you order at the counter, right? And you are like, we will bring the food. This happens usually not with one person, but with families, right? But if you order, we will bring the food to the table for you. Can we see that bringing the food to the table counts as table service and could then qualify us as a restaurant?
Say that again.
When you order, like table service includes two things, right? Like usually in a tradition, again, just being not being legalese, just being like when you go to a sit down restaurant, like you would think about, table service means you ask the waiter or waitress for food, and then they bring you the food, right? In our restaurants, you do order at the counter, but then you go and sit down. We will bring the food to your table, right? We don't do it every time right now, but we would be happy to. We bring the food to the table for people.
Compromise.
So could we qualify for being a restaurant by saying we do have table service? You order at the counter, but we deliver the food to the table just like in a traditional restaurant.
Mr. Mark?
So,
then you would be, so in that case, you would, you're trying to say that you then become a restaurant because you have the food serve, because you have the waitresses. And as a restaurant, you could then also have car service.
Right. Because I don't have a business unless I can get the people to the food.
No, but I
I understand what you're saying. I
think
understand.
Mr. Marsh,
I just wanted to make sure I understood it.
yeah.
But that's very interesting. But you just said before, and that's a very interesting concept.
Yeah, it says
that 60% of your business was people ordering in advance. But would that include some people who then come in and sit at a table and someone's going to bring their food to them? Because it can't be like a small portion. It would have to be the majority of your business is being served this way.
Right, ancillary, Meg. I think that's exactly. I hear what you're saying, Meg, on that. It can't be ancillary. The in dining can't be ancillary to the takeout. I understand that, Meg.
So we supplied
but
some
by the way,
case
every
law.
restaurant in, okay, sorry.
No, we did provide some of the cases actually focused directly on that question, Meg, is how many tables do you have inside versus are you really purely just a grab and go place? And here you'll see in our site plan, we actually gave the square footage. We have a considerable amount of patron space to dine in inside. This is.
If you were going to turn that into a lot of people bringing the food to them, if you changed your operation slightly to make sure that all those people who are sitting at tables are actually getting their food brought to them, that would start to change the nature of your business operation. But I don't know. I know there's a lot of tables and chairs, but I think that it sounds like majorly people go to a counter, then they take their food from the counter and they go find a seat somewhere. It's
traditionally 100%. That's how it has been done. So this is what we happen. And again, we're a business. We try to respond to our customers' needs. When we started in New York City, we did not run anybody's food to the table because there were 8,000 people coming through the line. It was usually one professional coming down from their office. They would get it and they would hightail it back to their office. That is absolutely what happened. When we started opening restaurants in the suburbs, guess what? We serve a lot of families. A lot of those families have kids where all of a sudden now you got mom or dad, and now you got 4 salads and drinks. And by the way, being served in the to stay bamboo eco bowls that are not plastic fast food takeout bowls, right? So it's like a nice presentation, but by the way, dad can't carry it back to the table. So we bring the food to the table for you. Like that was just, we did that in response to our customers. So is that table service? I don't know. We don't have a waiter, like.
Nick, if I could just flesh this
we
out.
bring the food to the table for you. I think that
Panera does that. Panera does that.
Yeah, Panera does that.
Okay.
If I could just say, Mr. Marsh, you said something earlier, but as you started this conversation, you said, we don't like and we don't like. And I want to clarify something. Really and truly, I don't think I've heard anybody say they don't like.
Totally understand.
I think, no, I think what I don't understand is, and I think it would be helpful for your group to, you sort of put up this block by having a proposal that doesn't work because of the definition. I understand. I personally am not in the decision. I don't think the board's an advisory board for you, but I think you can look through and see how do you best fit and what variances, if any, you might need. Because we have that as a safety valve. But you can't run into a situation that's like, I mean, you asked the question earlier, can we open the door to serve? Can somebody come in and pick up their food? Of course. I mean, I would never think twice about that. But you've run into a situation where you've just gone dead against something that I don't think works. So I think you have different options here. And I mean, I think everyone concedes that the restaurant issues are strange because some of them have waiters and waitresses and they have to be served by waiters. But I don't know, then you could come in and deal with that, maybe. But I think that
First of all, I understand, David, that it's not a matter of you liking it, it's just a matter of the code, so I did not mean to. I am listening to our team present what we believed were interpretations to try to work within that code. And as a business person, I'm sitting here listening to the board being not receptive to those arguments. And so I'm just trying to save everybody's time by seeing if there are other paths that you feel more comfortable with us going down.
But
I think you got a pretty good case.
David, I'm sorry, Nick, if I can, and this is so bizarre, again, because most of the members of the zoning board know me from appearing, and normally I would be more involved, and it's hard to be here in my office and talking virtually, but Nick, let me ask you a question. If the option was for us to have a door, much like, I hate to say, refer to Applebee's back in the day, but they did have a designated area where a door was utilized, and that was their car service. And again, I mean, so these are things, because what we could do is we could reconvene with some of these suggestions, get some additional input from the board tonight, because I don't want to, we want to reach the end zone here. And obviously, I think there's a way we could do this, but I would also not, so we're not wasting our time and your time, is get some input from the Zoning Board of Appeals and the village planner in terms of, well, if we go this direction and we do satisfy the threshold of a restaurant, would that suffice?
I think the board members who've spoken have been clear that they don't think that, as you currently have presented, this is a restaurant. And if it's not a restaurant, then it can't have car service and it can't have outdoor counter. And the board members who've spoken have also indicated that they don't think, and that they think this is an outdoor counter. Therefore, if you came back somehow to demonstrate that this was a restaurant, then exactly how on those occasions when you had somebody bring food out, I don't think that would be the issue. Then would focus on, is it a restaurant? If it's a restaurant, right, where food has to be served. And the thing about Panera, which may make it a restaurant, right, they have, is it Panera? There's some restaurant where you actually get like you can order on their tab, you can order from your phone sitting at the table, and then they can bring it to you. So if you could work that out so that you
could have that too. You don't have to go to the counter. You can order on an iPad and go sit down and we'll bring you the food.
I understand. So what I'm saying is, if that fits within our code definition of restaurant, then you can fit within the code definition of restaurant. And as a restaurant, you can have car service.
Well, then they may need an interpretation of what served by means, whether that means ordered and served. But that's fine. But that at least that's not like a prohibition issue. Then you deal with it. And I don't know what the answer is, but it would depend.
Listen, one of the biggest concerns, this is going back to last year,
Did we lose? Oh, sorry. Never mind. I thought we lost Meg. Sorry.
It's because I've been quiet for a while, huh?
Yeah, go ahead.
No, you're in the corner on my screen.
Meg was nodding when I said I would run the food to the table. She liked that.
I was intrigued by your.
I will do that. And we have the iPads you can order on. You don't even have to order it at a counter. That makes me even less of a whatever that would be.
Listen, as I said, they came to us last summer, and I knew we were going to have challenges. But as they we're talking, and the concept was evolving about the fact that it's not, we don't order there, we don't pay there. I was like, okay, wait a second, this could work. I understand the concern that the members of the zoning board have about the fact that the Pandora's box, whether there's a exterior shelf or not, counter, this, that, I get the Pandora box, which you're concerned about. If you open up here, what could happen in the proliferation of these concepts where other entities may not take it as seriously and take as much pride as my client does tonight. We want to see this. The CHOP wants to be in the village. I know that the residents here and people that work in our community want CHOP here. So I think that, I don't think this is a period, and we'll see you later. I think that if we can work within the input that you're providing us, and I like seeing Meg Yergin agreeing with Nick. That's a good thing, and Dave he feels comfortable with certain concepts. I mean, we could work with this. And Greta and Abigail, I know we haven't heard much from you all, but we can work with this because I think collectively we could see this being a great asset to the community.
But I want to make clear to satisfy for me that it's a restaurant, it can't be occasionally you bring things out to the table. That has to be your.
Yeah, there's got to be someone who.
That if you come inside, you don't even have to go to the counter. I don't care how you pay for it or something, but you're going to sit there and someone's going to bring over to you.
I can't.
And someone is going to also maybe clean it up, like it suits. That,
honestly, Meg, just to before we try to run down this road, I can't give you that you come in the restaurant and sit down at a seat and someone comes over and takes your order. I can't do that.
I don't think she said that.
I don't think.
Okay.
I didn't say that. I said that all of the food had to be
served
to somebody who's seated, because that's what it says, and that's what it specifically says in the definition, is that you are served sitting in a seat. You're not served.
If you're eating in, Ms. Yergin.
It says that you could go to a counter to order, but you can't be served at the counter. It has to be brought to you in a seat.
Unless you're taking out to walk out. Right.
In which case you have to take the food with you.
Right. I got that.
There's a place I go in Washington, D.C. regularly, and I take my grandkids there, and you go in, and you order either on an app or when you get there, and you get a number, and you sit down at a table.
Right.
And then there's waiters that bring the food over.
I say we go on a field trip. Let's go see this place.
I think you should. It's very good food.
Just go to the Panera.
They have very good French fries, so you'll be in fine shape.
Just go to the Panera in Pelham. They do the same thing.
Yeah. I don't know. I mean, I think, look, you have options that you can pursue. You should make your analysis of them and which one is the least interpretation, the least variance. And if you need one, then you'll apply for it. This sort of has an opening, Robin, that's the way I see it. This has a threshold opening problem.
Let me ask you a question, getting back to what Ms. Yergin said an hour ago. Just in the event my CHOP wants to explore that further, the restaurant, and are you going to, let me rephrase this. We want to come back here in a month. May we do so on the same application, or are we going to require a separate or new application?
And you're referring to the special permit for the car service, because you have.
They're still on the interpretation question. So if you come back next time, you'd be coming back. So first we have the interpretation question, which was based on this window or opening. All right. If you come back as a restaurant, then that would be a moot point, because you're not right. There'd be no counter. So you don't need the interpretation. Then you would just need the special permit. Right.
It's a second special permit to get car service.
I'm not sure that's true. There's no standards that talk about a second special
But it
permit.
says, if you just listen, if you read the definition, it very specifically, to me, there's no other way to read it, that there's also a special permit for car service.
Yeah, it's a separate.
Automatic for all restaurants.
I see that it says you need a special permit, but you're already getting a special permit. So your special permit application, which you need
Why would
anyway.
you say you need a special permit within the thing that you already got a special permit for, if they're not alluding to another one?
Because it doesn't say it in the special permit.
No, but to understand, but Robin, it would just say you can have car service. you can have a car service. If you're gonna delineate a specific aspect or service within the thing that needs a special permit, you need a special permit for it. Obviously, it's not wrapped up in the general special permit for that definition.
The reason I
Is there
disagree
a
with you
separate section
is
dealing with
that
this?
assumes that our code and the sections of the code were all drafted with cohesiveness and coherence, and that isn't true. We know
Okay,
that
but
isn't true.
the
To
sentence
me,
reads, the sentence reads, car service shall be permitted by special use permit only. They would have no need to say that if it's a given that if you're an open restaurant, meaning you got a special permit, you can have car service, there would be no need for that sentence.
I don't agree, because let's assume that sentence wasn't in there. Let's assume that sentence wasn't in there. Could you have car service or not? It doesn't say. So would you be able to have car service? If it just said car service is permitted, the implication is that you don't need a special permit. To me, I think the fact that there's already a special permit and there's no separate standards in the special permit section for the car service, it goes in the special permit that you're getting anyway. But the special permit needs to include the fact that you're going to have car service.
I
So
don't agree.
now-
I think it's a second.
Okay, let's ask
Not
board
an issue on
members,
the-
what do you think? Because I mean, really, this is really going to be up to us. Dave, what do you think? Abby, what do you think? Greta, what do you think? You know, Megan, I think whatever it is, the majority wins and we'll do it. That should be the simple answer,
Well,
I think. And if you,
I think that it refers to it by special permit, not in the special permit. I think, is there a separate section dealing with car service besides that?
no,
There is a definition of.
It's a definition.
Oh, I understand.
there's no section in the special permit provisions. that
I
deal
think
with
it's,
car
I would say that it should be in the notice because under special permits, every special permit you have to be noticed. So they should
But look
notice
at
that.
But David, let's just figure
No,
out if
because
it's a second special permit or the same special permit. That's really the issue.
I
The
think for the
special permit-
application, it's separate because I think that a member of the public getting notified that there's going to be a, is everybody all right?
Everybody okay?
Go ahead.
Just a member or two? I think that if someone gets notified that there's a restaurant opening, it means there's a restaurant opening. I think if they get notified there's a restaurant and they want car service, since it refers to it by special permit, I would think you notice for separate things. You can hear them together. It can be on one special permit. But I think technically speaking, it's because the rules say, what is it? I forgot the section deals with special permits. There's a whole process for them. I wouldn't want to take the chance because I think then people could, I don't know. But I think the point is, what's the big difference? So they have to notify it. They put your notice out. That's all.
There were two separate questions, David. Do they need two special permits? Second question, do they need a notice? I wasn't discussing the
Oh, I
notice.
see.
issue.
I see what you're-
I was discussing the question of, is it two special permits or is it one? Meg is saying it's two special permits. To me, it's clearly one. I don't have a problem if you want to tell them to renotice, that's fine. Abby or
I hear
Greta,
you're
what do you
saying.
think?
That's a good question. Robin, I don't know. I probably feel it should be two, but I don't feel strongly. I mean, what you're saying makes sense too.
So
I
Greta
think,
or Abby,
for
what do you
purity
think?
purposes, it might make it nicer to keep them separate anyway, but then you give them but it should be, but excuse me, they have to be on the same one. Because it's a restaurant and you can't give them the car service one without the restaurant
Exactly.
one. That's it, yeah. So it would be a two-pronged special permit. Yeah.
Okay, Abby or Greta, what do you
That's a
think?
good point. Yeah.
I'm willing to go with all for one deal that, yeah.
There we go.
Greta?
I agree. What David said makes sense.
I
Okay,
also
so
want
I
to
think the
clarify that they-
conclusion is that it's one special permit. You don't have to submit a new application for the special permit. You're just amending it, but you do have to provide a new notice that clarifies that it's a special permit, including car service.
You have to request the car service when you're requesting your special permit. It's
So they
not
can
You have to
amend it.
indicate how it's going to work.
assumed ability to have car service.
And Robin, they'd have to indicate how it would work and what it
Right,
is.
and they can, they can explain it to us next week, next month at the hearing.
So just so I completely understand and I
If
appreciate.
that's what they want to do.
Thank you. And Mr. Newfield, we did that to throw a curveball and you make sure you didn't lose your game since the last time you were sitting here. You're doing pretty good there. With that being said, so we would need to get a letter from Mr. Tavalucci in the building department of our letter of denial. And
No, you don't need a letter of
Okay,
denial.
I just want to make sure. Okay. Just,
You're
No,
not,
no,
all
you
you're
can
doing
refer.
is
A special
amending
permit's
the
referred.
special permit to add, you're amending the current application to include the car service because you're going to need new drawings or whatever else you're going to need. However, because the car service is potentially something special, you should resend notice to the applicant so it doesn't just say special permit for restaurant. It should be special permit for restaurant, including car service.
And by the way, car service has another section. It's 342-3B.
Right, the definition.
No, that's not the definition. For some reason, I just found it.
342.
-3B paren 12 or something. It says here, car service. Unless
Yeah,
it's-
but that's the there is no
maybe
other.
the same one. It may be the same.
It is the same, David. I already went through that.
Oh, okay.
It's a very weird way that the code sets up.
A little bit, huh?
Oh, no, Dave, it's because if you go to the very beginning of 342.3, A is the paragraph that says terms defined, and then B is, as used in this chapter, the following term shall have the meaning indicated. So this is 340, all the definitions are
I
in
see.
342.3B, and this must be not the 12th definition or whatever that number is.
I got you.
So that's what it is. Anybody, Abby or Greta, want to add anything? And then we're going to open it to the public in case there's members of the public out there before we proceed.
I just want to add that I pretty much agreed with all of you, which is why I've been quiet. But I think this restaurant new path seems like it works to me. So I'm looking forward to it.
Thank you, Abigail.
Okay, does anybody from the public wish to address this application?
I don't see anyone who wishes to speak.
Okay, if Mr. Stats, if you or your team have nothing else to say, then I think we'll adjourn the special hearing, the public hearing on this application.
And we'll just I'll have to go over the schedule with regards to sequencing, making sure we have enough time to renotice before your next. I don't know if Charlie or Amber, if I can, I believe the deadline for zoning board is today's, okay, so the next one is March 4th. So our deadline is, okay, it would be February 11th for the amendment.
That's correct.
Okay, all right.
And then 10 days before the hearing that you would need to have notice sent. So if you get it in by the 11th, you should have time.
Very good.
All right, thank you all, and we
Appreciate
will
it.
see you the 1043 West Boston Post Road application is adjourned.
Okay, I'm sorry, Chair, if I can, just my team, if we could go onto the Google Meet right afterwards, that would be great. Thanks so much. Thank you all. Have a great night, everybody.
Thanks, everybody.
Thank you.
Okay, the next public hearing is 1035 9 Acres Lane. I don't see an application number. If somebody has
Yeah, hold on.
They were not included on the agenda.
right, but I didn't see it anywhere, so I didn't see it on the
Um,
application either. So if someone else has it, that would be great. If not, we'll just, I mean, we don't need it. We should have it, but we'll have to make sure next time that it's there.
It's not on the papers I have either.
Right, so there is no number for that one. So 1035 9 Acres Lane is an application for a special permit to construct a pool. I know board members had questions about whether or not this was appropriately here at the board. Do you want to discuss that first, or do you want to let the applicant make their presentation first?
I know that we just received something at 4:30 from the applicant. I don't have any time to look at them. And so I got a piece of material that I can't look at. So, and I don't think that we should go on with a review when new material just came in that we're not.
We have in the past, when that happens, said that we would have the application and we would, since they were here and it was noticed, that we would have the discussion and that it would have to be adjourned. We couldn't close it because there was new information. That's
I
what
thought
we've
that you
done.
did not allow them to
Or we don't, and we, because we're not continue, we can't consider that. What we had decided is they weren't supposed to be able to submit. That's what we had decided. So they weren't supposed to be able to submit this close to the hearing. If, however, at the hearing, since we know that if this were a live meeting, applicants often brought new material with them to the live meeting, we wouldn't then, and that new material was relevant, we wouldn't make our decision because of course we wouldn't have had time to review it. So,
Okay, I thought you had made a rule, you couldn't even bring it to the live meeting. I didn't understand that.
I don't know if we did, and if we did, doesn't matter. So if we don't consider it, we don't consider it. Since he's going to want to submit it, we will consider the application without that, and then he'll submit it the next time. I'm not sure that it's a substantive difference, but.
Hey, Rob, and Ashley is raising her hand.
Yeah.
If I could just clarify, what was circulated to the ZBA today was in response to the village engineer's memo that he wrote to the planning board. So it was a follow-up on something that was being discussed at the planning board. It was more of an FYI for the zoning board of appeals.
Okay, so going back to my question, do we want to discuss the issue of whether or not this is appropriate, that they need the special permit from the ZBA? Because I know some of the members raised that before we let them speak, or should we just let them speak and then discuss
I
it?
think that makes sense. I think it makes sense because if we determine that they don't need a special permit, then that will expedite
Right.
the,
So I'm
the
speaking
meeting.
to the applicant now. Do you understand? There's some question on the board. Some of the members of the board had raised the issue of why you should need the special permit from the ZBA in the first place. And so that was an issue that we had. That was a discussion we had. No, we didn't have. And so that's the discussion that we're going to have first. So just sit back and hold tight and wait while we have this discussion. Okay, David.
Sure. I looked into this because this concerned me. I'd never seen one of these before, probably 25, 30 years. And I took a look at the code. In chapter 300 of the code, which is not part of the zoning code, but part of the village code, is very clear. It sets forth, and it's entitled swimming pools. It defines the pools. It sets out the standards for the pools. And it says, you want to get building, you make the application to the building inspector. The building inspector reviews the standards and reviews your submissions. And the building inspector then either issues the permit to you or declines to. If you don't like it, if you're not happy with the building inspector, 300-7 provides you take an appeal. And that appeal is to the Board of Appeals. You appeal from the building inspector saying he improperly refused to give you the permit. And that's the way it's been, to my knowledge, historically. So I don't understand how this came about. So I looked into that a little bit. And what I was told was, and I have no idea, that somehow the planning board or the building inspector had thought this was the way to go to turn these into special permits, and you should go this way. Well, the problem is multifold. Number one, we're the body that's supposed to take an appeal from the building inspector. And we can't vary 300, I believe, because it's not part of the zoning code. It's a separate code. It's the main body and not part of the zoning code. And the example given, and I think I got this from council and someone else, was that 34267, they say, indicates, well, that changes everything. But it's always been that way. And it says all uses listed in single-family dwellings, non-residential, et cetera, as subject to additional standards are declared to possess certain characteristics, and then it lays out the special permit uses. Okay, I don't think that this is an additional thing. It's part of the main body of the law. But then, to avoid any issue, if you take a look, I made my notes here, but if you take a look at that section, which is the special permit section, and you get to the section dealing with pools, there's a little section on it, and it says, well, what does it say? It says in here somewhere where I have it, swimming pools, 34249, and it says, no swimming pool shall be constructed or maintained except in compliance with section 300. Okay. I mean, they said, hey, go over there. That's where you're supposed to be. Section 300 says you make your application to the building inspector. The building inspector makes a determination. If you don't like it, you appeal. So even the special permit section refers you there. Now, I can't locate anything that makes a pool subject to it. Moreover, I think it really creates, I think it's creates a complete re-legislation, because right now 300 says the building inspector makes it and we get the appeal. If we're going to issue the special permit, then we just said to the building inspector, you've just been deprived of that, and we've also no longer take appeals from that. So also it makes us, we're going to impose conditions, because under special permits, we always have that right. I've never seen this happen before, and I think it's a real problem. I don't know why it's here. I heard that what I was told, and I'll repeat this, is that first I was told it was the planning board. And if they wanted it, don't want it, that's fine, but they can't just, they're not the legislative body. Certainly they can't just change the building inspector's authority or ours, or the building inspector. But I think if the building inspector is here, maybe Frank can enlighten us on that, because I've never seen this before. And it really does. It's a whole different world of dealing with the pools and everything else. So I don't know. To me, it would be a complete modification of the code if we were to take special permits, because you cannot take section 300 and make it compatible with us giving special permits. And by the way, one other thing, special permits, when someone wants to have something that's subject to a special permit, it has to get referred to us by the building department or the planning department. People don't come and just file with us. It's a referral process under our code. Here, the person who's supposed to make the decision is not going to say, oh, well, I've decided not to, I'm going to refer to them for special permit. So I don't know. To me, it's an expense. It's an involvement. It's just creating a whole thing. So my feeling is, I don't know why it's here, and I've never seen one here. If anyone else has, I'd love to know about it. But I have never. I've been on the board 20 years on the board, but 10 years additionally, I lived in the area between being on the board. I've never seen this before, and I really am baffled by it. And that's it. I've said enough. Goodbye. Bye.
I have I don't know the answer to this. It was news to me too. I'd never seen it before, but my approach is different. If you look at Article 10, 34267, and this is where I think I'm perplexed because I don't know the right answer. And I will say, if in fact the board should have been granting these all along and never did, that doesn't make it right to have to not granting it now that it's pointed out to us. If we should be granting it, then we should be granting it. If in fact we can find the argument that we shouldn't for whatever reason, then that's right. Okay, 34267 says all the uses listed in Articles 5, 6, and 7 as subject to additional standards and requirements are declared to possess, and then it gives the process for getting a special permit. Okay, swimming pools are listed in Article 7. Because they're listed in Article 7, they have to, it seems to me that 34267 means you have to comply with Article 10. Now, I do agree with Dave. How do we do that? We can't apply because 34249 says you get a special permit if you meet Section 300. Well, Section 300 is supposed to be interpreted by the planning board. So
No,
I agree.
by the building inspector.
I think the code is internal. I think both sections are very clear, and I think our code is internally inconsistent. And I think we have to make an interpretation as to how we want to do this. And I think we can interpret this to say, look, since the standards are all in 300, and given that the standards are all in 300, given that you can appeal a denial to the ZBA, and since the two sections seem to be inconsistent, that it makes sense that we are saying that you only get the 300 special permit, and that if you get the 300 special permit, you have satisfied the requirement for a ZBA special permit, and you're done. So I'm okay with making that interpretation, but I think we have to make that interpretation.
But Robert, if I could just respond to that for a moment, just real quickly, I think that I don't agree. And first of all, I think there's no option because 300, otherwise you're completely eradicating, correct? You're taking a pen out and you're crossing 300 out. Okay, but not that. When you say additional requirements, everything in the residential and non-residential has additional requirements. They all list them. They're all in there for everything, whether it's a house or anything. The question I see, I read that as saying additional requirements that are consider parking, consider all these other things, which is how special permits come up. But Robin, even if you take a look at that, even under the zoning code, it says swimming pools. No swimming pool should be constructed or maintained except in compliance with the provisions of section 300.
I agree.
I mean,
Jay.
it's not much of an interpretation. I think.
But our interpretation, arguably, you could also read that as saying you have to get a special permit from the planning board, and then having gotten the special permit from the planning board, you have to get a special permit from us under Article 10, and that makes no sense, which is why I'm saying we interpret it to not require that.
But Robin, it's not talking about the planning board. I don't know where that's coming up from.
That's who issues the, isn't.
No, it's the building inspector. That's the point.
So then it's building inspector. It doesn't matter. The point is there's some other section that says you have to make these, you have to make.
Section 300 is got he's got 8 sections in it.
David, look, I don't disagree that that's crazy that they have an application. Oh, it's the site plan. So they have to go for site plan approval.
That's different. Yeah.
That's why that's why they're at the planning board. Okay, it's not for this pool. But I think that so given that it's not the planning board and it is the building inspector, then it's actually harder because the building inspector, when a building inspector issues building permit, he's making sure that they comply with all kinds of other section of our code. So it is common for someone to go to the building inspector, get a determination of something, and based on that interpretation, then they come here for certain things. You could take the position, I don't want to do this. I'm not suggesting, I'm trying to say, let's interpret it so we don't have to. You could look at 300 and say, okay, not 300, you could look at 342.67 and Article 7 as saying that in order to get a special permit for a swimming pool you have to get a special permit from the ZBA for a swimming pool. What are the standards for a swimming pool? The standards are set up in section 300. If the building inspector determines that it meets the standards of section 300, then you can get the special permit from the ZBA. I just think that's unnecessary, given that we're not, so it strikes me that we should make the interpretation because the two sections seem to be inconsistent, but you can also read them as saying, no, they're quite clear. So I think that's why we need to make the interpretation.
I don't know if this is pertinent, if you're ready to say that it doesn't need a special permit from one of these boards, but is it for sure saying in 342 in Article 10, and if I go to 342-69, it says it's referred to either the Board of Appeals or the Planning Board. Is there some place where it specifically says it's the ZBA that gives a special permit and not the Planning Board?
Article 7.
It does say that? Okay.
Article 7 applies to just turning to, Article 7 is the, Article 7, standards for use is subject to special permit. Everything in Article 7 is the ZBA.
And 300 refers the appeal to the, from the building inspector here. Robin, one other thing that makes it very unwieldy is the building department has to now refer it to us so that they can then do anything and then they can appeal it to us. Anyway, I would suggest then and by the way, we've never done these before.
Correct. Meg, the answer to your question is 342.39 says the following standards are to be considered minimum and may be increased where required by the Board of Appeals as a condition of approval under Article 10. So the implication is that it's the ZBA.
And but 300 is, and then 342.49 refers back to 300.
Yes, it's like, as I said, I think it's internally inconsistent, but you could also read it to be, those are the standards, and it's no different than any other provision of our code. You know, do they have the right amount of light and air? Do they have the right room size? Do they have elevators or stairs that meet other code requirements? You could look at it and say it doesn't mean any other difference in that. So Abby, Greta, Meg, what do you think?
I think you could also argue that the code is ambiguous and therefore you have to interpret it in the most favorable way for the applicant, which would mean that you would not request a second special permit from the ZBA.
I agree with that. I think that's a good way to look at it.
I also think that if all the standards are in chapter 300 and we don't have any other guidelines for what it is that we're supposed to be measuring against, I don't know how we would go through the process.
Right, that's what I think. That's to me the reason that it makes no sense.
I mean, we could go to 300, but it doesn't, that looks like it's under the purview of the building inspector.
Right, with us as the appellate.
But it does look like something got mixed up because it does talk in 300 about whether it's causing noise or it's bothering neighbors, but it's in 300. So it seems like there was, something wasn't thought out and something was meant to be here or it was meant to be there, but it's not that way right now.
Okay, so does somebody, I would make a motion
make a
because
mo-
my problem with interpreting it to say when it's ambiguous, the benefit goes to the landowner is if you take that position for everything that our code says, and there's a lot of places where our code is ambiguous, we don't have to grant anything. I mean, there's too many things out there that are ambiguous. And I would rather leave it if we can come up with another way. And to me, I think based on history, based on the fact that it doesn't make sense or something else, I would want to make that, an interpretation based on all that rather than in the case of ambiguity.
I would propose a motion that would say basically that swimming pool permits that have historically been issued pursuant to chapter 300-1, and the board is available for appeals, and 342 of the zoning code refers back to saying 300 has to be complied with, and therefore there is no express requirement for a permit for special permit, and the building permit should be proceeded as they have been historically under chapter 300 with appeals to the board.
The problem with the
Yeah, I don't
language
see the
is, I think,
ambiguity.
my only problem with that language is I think the special permit is pretty clear that they have to come to the ZBA. I think our
Why
interpretation
do you
is
say that?
that
Tell me
section
that.
300 is no different than any other provision of the village code. And if they are denied, they can come here. That's why I think it would come.
You're relying on that that opening line that says additional standards, right?
And what section 7 is. Section 7 is additional standards. That's what section 7 is titled. Construe standards for use is subject to special permit. So by being in section 7, it is necessarily subject to a special permit.
Isn't but in 7, if you take a look in 7, 342-49 says no swimming pool can be maintained or constructed without complying with 300.
Correct.
That's
That
the-
doesn't mean that, but as I said, you could also take the position that means, okay, first you get your permit from the building inspector, and then once you get your permit from the building inspector, you have to get a special permit, which is clearly nonsense. It makes no sense because we're not doing anything extra. Therefore, I think that because there's nothing extra required, that there's no reason to come to the ZBA.
Yeah, I don't care how you write. Yeah. And does anyone know how this came about?
Somebody
Yes,
was reading the code and saw this.
It was raised by the new attorney for the planning board. She found it when she was reviewing the site plan.
I would hope in the future that she would confer with the zoning board before she at least get some input. It's sort of like
Okay, so
change.
I think we're all agreed that we can make an interpretation or
Yeah.
that in fact you don't need to come here for a special permit. Are we all agreed on that?
Yeah.
Yeah, that's fine with me.
So Charlie, if you would draft a resolution to that effect based on what you heard tonight, and then we'll review it, and then at the next meeting, we'll come up with.
Is Charlie here?
Yeah, he's here.
Absolutely.
Oh, I
That
didn't know
sounds
you
like
were
a
here,
plan.
Charlie. I'm couldn't even see your name. Oh, you're at the very bottom on the next page. There you are.
If you're anticipating going in that direction, do you have any objections to the planning board continuing their review and granting site plan approval next week?
No. Anybody else? I don't. Does anybody have any objection? Okay, so Barack, you're the applicant. What that means is you don't have to be here, even though you're here. So you don't need a special permit from us, and we're going to come up with an interpretation that says you don't.
Great, I appreciate it. I just have one quick question. The building inspector was referenced multiple times. I believe he's on the conference here, so I just want to make sure that he's also in agreement with everything that was discussed. I just don't want this to adjourn and then to find out later that someone in the process doesn't agree. We started our application in August, so it's kind of been dragging on quite significantly through all these different boards. So, to the extent possible, like, I just like to know that everyone's in agreement before we decide to dismiss this.
Frank?
Yeah, I am in agreement. I don't know why that chapter 300 even came into this picture at all, that 342, 49, 300. So I'm in agreement that you don't have to interpret.
Great, thank you.
Okay. So the hearing is closed. Oh, wait, is anybody here from the public if somebody wants to speak on this?
Yeah.
I don't want to deprive someone of the opportunity if they've come to speak.
I don't see anyone who wishes to speak.
Okay, then this hearing, motion to close the hearing. I don't know if we need to close. We did open a hearing, so we have to close it. Motion to close the hearing.
So moved.
I second.
All right, Abby,
Yeah.
Greta,
Yes.
Meg,
Yes.
and David.
Yes.
Yes, and I vote yes as well. So the public hearing is closed and we will, and we'll get a resolution that it makes an interpretation. Thank you.
Thank you.
I lost my agenda. Oh, no, the next application is 1139 West Boston Post Road. This is an application for a special permit for a delicatessen. So I see the applicant is there, Mr. Audi. I'm not sure if I pronounced it right. I apologize if I pronounced it wrong.
Is he here?
Yeah, he's here in some form, but not here.
You may need to unmute yourself.
Have hand cards, we hold them up.
Can you hear me now?
Yes.
No, we can't see.
Yes.
Here.
Here you go.
Mr. Audi, before you start, I have one question that I noticed is not in your application and we need to see, which is zoning calculations, because we don't know about parking. And I recall, and David, you may recall this, there has been in the past issues about parking for the restaurants that were here previously.
Okay.
I don't know whether or not what you have in the way of parking, but we need to see something to be able to determine as part of your special permit, just to let you know what we're going to need for next time. And now if you want to present, you could talk.
Yeah, okay, that's fine. That works. So basically, we own over 33 locations here in New York City, very high-end delis. We focus on very healthy foods, make your own salads, smoothies, all protein bars and that kind of stuff. Basically, the application stated all. We've been in business for 20 years. So,
is it a restaurant or is it a take?
It's a deli.
But do you say, when I say is it a, do you, it looked like there were tables. Are there tables? Are there not tables?
Yeah, there's tables.
So it is, I mean,
and is it majorly single serve orders that you're producing and selling, or is it like some bulk items that people are taking home?
No.
The deli, you're getting a quarter.
Single serve. Yeah, single serve. And we also do catering as well for special occasions.
I'm not sure I would consider it a deli, but
Something that's defined.
in that space, but it certainly seems like it's more of a fast casual, one of those hybrid carry out fast casual deli food establishment. It sounds like a food establishment.
Yeah.
I think if you take a look at the definition of delicatessen, it's it's food off premises consumption.
Yeah, so I think it's more of a fast casual, but we've definitely approved special permits for not the same menu, but we have approved, for people that operations that could be considered fast casual or carry out or whatever those definitions are. What I didn't see was I couldn't see in the site plan, you're taking over the space that was a restaurant before. I think it was La
Yeah.
Gladys and it was I Am Burger before that. And the other space is going to remain empty from right now. You're not taking over the entire building, or you're just taking over the restaurant space. Is that correct?
Yeah, just a restaurant.
So I need, I'm sorry, I just would like some sort of site plan because again, as we consider parking, which I know we have given special permits for your space before, I just would want to understand how the whole place could be fitted out when we consider what we think is appropriate in terms of parking.
The building does have sorry, cut you off. The building does have parking on the side and in the front.
What we determined last time, and again, this is not, it may not be true for yours because of the way your restaurant, your deli operates. They didn't have enough parking and they had to work out an agreement with Equinox.
I've already spoken to the manager.
Okay, so to allow for the use of the Equinox lot, and we needed some evidence about it. So I don't remember exactly what the deal was, but there was something that needed to be worked out. And in order for us to approve this and consider all that, we need information about seats and parking, employees, and whatever other information is relevant to that consideration.
Could the planning department provide this applicant with the resolution from La Gladys or I Am Burger or whatever it was that worked out the parking agreement with Equinox, just as a template for what we're talking about? What was?
I think it was the La Gladys because that was their first, and they're the ones where it came up, and then I Am Burger just followed through on that, I think.
So the planning department can certainly look for the records. I think we will want to confirm what document specifically that would help in order to get that to the applicant. So we'll offline.
I need that, but I would also like to see a site plan to understand the square footage that's remaining empty and what square footage you're taking over.
Okay.
Okay, so Mr. Al-Audi, what are you going to be your hours? Just give us some more information about how you operate, please.
So we open at 6 in the morning and we close at 4:30. But if it's really busy during the afternoon, we would extend our hours.
So if you had the choice and you can go less, you would be like 6 to 6?
Yes.
I'm just saying that because you didn't have that in your thing you put down.
And is it seven days a week? Is it 7 days?
7 days a week, yes. Like every location that we have different hours, it's all about the neighborhood and location. Like we do have one in Armonk, but we close at 4 o'clock.
Now the tables, how many tables? Let's see, you have a table service thing I saw here?
Yes.
So how many?
Do you have wait service to the tables? Do you have people taking orders or bringing the food to the tables?
The person who's working the cashier will be bringing to them.
And how many seats do you have? How many seats will you have?
Currently about 40, but we are flexible.
I thought you said 52 actually.
Is it 52?
But also how many staff members you're going to have working at a time?
5.
And so you have use of the parking lot that's on that space? I know you go through a driveway and the parking lot is basically behind the building.
Yes, we'll be using that, and also the front has parking, not as much.
On the
But of
street
course, Equinox would definitely, I did speak to the manager, he was okay with that, but I would follow up with him regarding proof.
What's
the
requirement of parking?
The application says it's for 1139 West Boston Post Road, but the sign for the hearing was in front of 1137. So I was confused about where exactly the restaurant is going, where your operations are going to be, which piece of that building.
The
And I couldn't
left-hand
tell from,
side,
maybe
Burger
make
King.
it it better. I couldn't tell from the plan exactly where it was.
it used to be a restaurant there, so that's the exact same location, and we're not really doing anything much to it. It's just removing the bars and putting a deli case. That's all we're doing.
Okay, then you have to move the sign because the sign is in front of 1137. It is not in front of 1139.
Oh, I had the architect put it there. I mean, the sign guy. I'll have it removed.
You just move it over. Don't remove it. Just move it
Oh,
over.
yeah, definitely, definitely.
Then there's a survey. In the survey, I didn't see any dimensions on the survey, which was why I was having trouble figuring this out. And it isn't actually a survey, but the thing that's closest to a survey, and there should be a survey with all applications. So that's a requirement in our code. So I didn't see a survey that had dimensions, so we need something that shows that.
We did a survey, actually. We had the architect submit it.
And Ellie has one, yeah.
Is there one that has dimensions? The thing that I saw that looked like a survey didn't have any dimensions. Well, if you would just check, please, and if it's not there, please submit one.
Okay.
What's the date on the survey? Let's see.
Um,
Oh, 2017.
We require it to be redated within a year.
Yeah, yeah.
We just did it like last month.
Then we don't have that. So if you've done it, please just have it submitted.
I'll have
Oh,
architect
excuse me,
submit again.
excuse me. Robin, I stand corrected, Mr. Chair. It says here survey is, boy, glasses aren't working well. October 27, 2017, an updated
Yeah, that's what we accept.
12 something, 2020.
Yeah. Then that's right, that's fine.
Yeah.
But does it have dimensions on it? I didn't, if so, then I just didn't see it. I'm not.
Yeah, I think it has the exterior, you know, the property line, not interior lines.
No, it does have exterior, then I must have just missed it. Okay, if it's there, it's there. I missed it.
It's hard to read some of these because they're small. You know,
Yeah, no, I expand them when on my screen, but I didn't see I missed it. Okay, that's fine. You know.
So
Do
basically,
we
all we
have
need
something
is
with
parking.
do we have something with the square footage of the entire building? Maybe you do, but I didn't think that you did. But I understand the amount of square footage that's going to remain empty. Is that there?
Should be in the survey, but I'm not sure how big is the building.
The total building is 10,395.9 square feet.
So if you could put that all in information in the application, you know, then it would be.
Doesn't this have to be redone as if it's not a deli, because it doesn't fit within the delicatessen definition? I mean, this is an application for special permit for a delicatessen.
Yep. But then we're going to ask him to notice it as a food establishment because it doesn't fit anything else that's pretty tough.
That's fine.
Well,
I think it was noticed with the section of code that refers to food service establishment.
So if it referred to the general food service establishment, I don't think it really fits really easily into any of the other special categories. So I would think that that's sufficient.
All right. Is there anybody from the, is there anybody, David, sorry.
Yeah,
David
one
has a
sorry.
question.
No, I'm sorry, Rob. Why doesn't it fit into a restaurant? I'm just curious. No, it also has other things. I guess you can buy delis there, but it's a business engaged in the preparation and sale of food and beverages selected by patrons, waiters, bring it, consumed on the premises.
Right. Now that we see that you only have to actually order at the table, as long as you're serving it to the table,
Right.
it still meets under a restaurant because.
I'm just.
You're right. You're right.
I don't know, whatever, but not a big issue, but I just,
90% of the time, our customers do order and pick up and leave, or they order online, come inside, pick it up and leave.
So the majority of your business is not as a restaurant, it's as some other.
Takeout place.
Yeah, just take out. But they do have an option of sit down if the weather is bad or something.
I don't know that it matters. They went for, it's a food service establishment. I think as long as we, I'm not sure that it matters for this.
Okay.
Does anybody from the public wish to address this application?
I do not see anyone who wishes to speak.
Okay. Mr. Ali, do you have anything else to say, or does any board member have anything else to ask about this? Sorry, Dave, you look like you had something.
Well, if you take a look at the definition, is this a restaurant carryout? It says business enterprise primarily engaged in the retail sale of food or beverages, which may include grocery items for consumption on the premises, but which also includes the incidental sale of ready-to-consume food, of consumption off the premises, but also includes the incidental sale of ready-to-consume food and beverages from countertop installation for consumption on the premises.
Yeah, this is where we always have this problem that we have these definitions that kind of fit, they don't.
Well, this sort of fits, doesn't it?
It does, but we just always fall, I think what we've been doing historically, the last year or so, is just call things food service establishment.
Okay.
And since, yeah.
I'm good.
It's
Much
hard.
of it matters, except for the restaurant issue of the Chopped with the car service. Almost nothing else, it doesn't really matter as long as it's within the generic definition.
Yeah, it's tricky. Especially when you understand that 90% of the business is not going to be sit down and you're trying to determine parking spaces and you're going by seats and someone just told you that's not actually the majority of the business. How do you figure out what is the appropriate number of parking spaces? It's really, there's really a gap in the code.
Mm. Well, it's also because it's so near the high school, I'd imagine that's where it's going to be a lot more foot traffic than you would normally have versus parking.
Yeah, but I'm just trying to look what are our code requirements that we don't have any choice about in the code, you know, what it tells us about parking. Because then it would be like for a parking variance, we would consider that, but does it even need a parking variance?
Right, and so the question
And
that,
then it goes back to what was the business before and what did we give the special permit for?
and that's before it was definitely a restaurant. Certainly the La Gladys was a restaurant, which was the first one. So the fact that it had parking issues may not, was because it was a restaurant, like a real restaurant, sit down, and that's mostly. So it may not, those issues may not be relevant because if it's not a sit down, it probably needs fewer parking spaces, in which case there may be no issues about parking at all. So there's the. Okay, anybody have anything else before we adjourn this? Charlie, did you want to say something since you appeared? You're on mute.
Oh, sorry, I had a toddler behind me for most of that presentation sleeping, so I thought I'd turn off the camera, but everything seems in order.
Okay. J. Justin Woods, are you part of the applicant team since you're there? No. So who is Justin Woods? Amber?
His hand was raised, perhaps. I actually, I have to say,
Mr. Woods?
I went to.
I'm here for the next application, Madam Chair.
Oh, okay. Okay. So I think that's it. And nobody else has anything else for Mr. Al-Adi? Okay, then this hearing is adjourned and we'll see you next month.
Right, thank you.
Thank you.
Bye.
Bye.
Bye. Good evening.
Robin, I'm really sorry. I have to go. I got to put my kids to bed. I can't stay up any longer.
Okay, so, okay, well, there'll still be four of us. That's a quorum, so we can continue.
Okay.
Without you and.
All right. Take care, everybody.
Good.
Bye night.
Good evening. Take care of the kids.
Take care.
I'm very good at reading them. I just took my grandkids for a week.
So Abby, if you've been, he's offering.
Oh, you're going to take my, that's great. That's great.
Twins and I mean,
I'll take it. I'll take it. Anyway.
3 to
good night,
10.
everybody.
The next application is 130 Beach Avenue, which is first an interpretation, and then depending on how we interpret, reach that interpretation, a variance, but I don't think that we have to determine what kind of variance, and they did not get the necessary objection from the building inspector for the variance. So if we determine that it is appropriately here and needs and should get a variance or something, if we determine that it's appropriately here and should get a variance, then he will have to go back to the building inspector to get the necessary objection to come back to us in accordance with the.
I'm sorry, I thought he was asking for an appeal of what the building inspector, I thought that was also a variance, but I thought it was majorly requesting an interpretation of the directions of the building inspector.
Yes, but if we decide that we should not, that we can't, that it isn't appropriately that the interpretation doesn't give him what he wants, then he wants a variance to allow it. That's what his application says. I can't.
But I thought when we have an interpretation of a determination by the building inspector, becomes a de novo review, and we can say what should have happened.
We cannot, if we decide that, if he's asking for an interpretation that essentially that the alterations can't be enforced, that the requirements of the building inspector can't be enforced, okay? He's asking us to say, if we agree that they can't be enforced, that's done. There's nothing else to consider.
I would ask counsel, okay, I'm asking the question then, is that for sure? I would like to ask our counsel. I thought that we stand in then and do the original review. What the building inspector had done was consider what was required as a result of the determination of this board. And we take a look at it, and it's a de novo review, and we can overturn and we can say what should have happened. So I took that to mean that we could say what is the appropriate response to remedy the situation as a result of the determination of the resolution. I thought he then said, if that requires a variance, he would like to make this application also the request for that variance, but I didn't think that that was his only choice. I thought we get to say what the building inspector should have done. That's what I understood when I read the code as to what our responsibility is in terms of interpreting building inspector determinations. So if I could hear from Charlie.
Sure. So the way I understand the application as I reviewed it is an appeal of an October and a November, and I use the term loosely, determination from the building inspector. There were correspondences from the building inspector. That's your threshold question, whether you can hear it, as well as, the substance of it. From there, I believe the application identifies an area variance request, and it's listed as though, and I forgot if it was the October or the November building inspector correspondence, I think the October. And it had a list of items that the applicant needed to do to bring his property into conformance. He is requesting area variances based on those items that the building inspector correspondence listed. I think one of them was the use of a kitchen and then the third unit and so forth. After the appeal is handled, you would then consider those area variances as you see fit. Those area variances change because of your appeal. I would see no reason to go back to the building inspector. However, a question of whether or not those are actually area variances, I think should be considered by this board, whether or not they're area variances or in fact use variances.
Okay. But I'm confused because we had a resolution, and those on the board who were writing the resolution actually said, we are not going to provide the remedy. The building inspector is going to provide the remedy. And the remedy is a classification in village law. It's called a remedy. So I take it that what the building inspector wrote, it took two letters. First, he had one remedy, and then he was asked about another aspect of it, and he wrote another letter. But I take that as a discrete letter with a remedy for what resulted as the determination of this board. So I thought we have a de novo review of that. And when we do a de novo review of something that the building inspector has provided, we say what should have happened. So it is not that we then say what is the correct remedy for that resolution. That's not, we simply say it's good, it's bad, you need a variance or not. If we say that the building inspector was, I'm not saying this is what's going to happen, but if we say the building inspector was incorrect in for whatever reason we find that he was incorrect, it is not within our purview to say what the building inspector should have done in that situation. I thought that's what happens when you have an appeal such as this.
Yeah, you're correct. So if your review of the remedy results in, and I think I'm characterizing this right, results in a need for additional relief, area variances, there's no need to go back to the building inspector to clarify those variances.
But what if it's something that doesn't need an area variance?
Then that's
It's a different way of interpreting the resolution and saying, we would like you to do this, and it doesn't require an area. You keep saying it needs an area variance.
Gotcha.
What if our remedy doesn't require an area variance?
Well, let me
And
ask the question.
that would be, oh, just hang on one second. I now understand what you're saying. So what you're saying is the appeal is based on the remedy that the building inspector has determined. If you find it appropriate to hear that appeal, then you are correct. Your interpretation as to the remedy would hold. If you get to the point where, this board feels it necessary to hear that.
I have a different question. We said at the time of when we issued the resolution that we were going to leave it to the building inspector to determine how to fix the problem. Okay, so the building inspector told him how to fix the problem. He is now questioning whether or not that was appropriate. Since we already said as a board that we weren't going to tell him how to fix it, isn't he asking for something that we've already determined, and he's really asking for a rehearing of the same thing? Because
No,
we already said,
Absolutely not.
we
Absolutely
already
not.
said, let me
Excuse
finish,
me,
please.
Mr. Woods,
Whoever
if we
you,
could just let the
excuse
board
me.
talk.
And then you can identify yourself before you speak. If he is asking for something that we have already said we're not going to do, isn't it a rehearing? So I'm asking counsel now, if whoever Mr. Woods is wishes to speak, then after Mr. Gottlieb speaks, you can, and we haven't asked for any rec speech now from the applicant. So right now we are having a discussion among board and its counsel. We will, after we finished our discussion, then ask the applicant. And if you are speaking for Mr. Teekert, then you will have the opportunity to speak. That's how we are doing this right now. We are discussing it internally before we open it to the applicant. So Charlie.
Sure. So, I do understand there's history here and an Article 78 somewhat related to the matter before us. So it is incumbent on this board, before hearing anything from the applicant, to make a determination whether or not this appeal is barred by administrative res judicata. That meaning that this appeal includes the same parties, events, property, and so forth, and arises out of the same facts as your prior determination. If you find that that is the case, then this issue is barred by res judicata, and happy to provide the cases on that, etc. That being said, there is a mechanism in Village Law 7-72A12, which allows a ZBA to rehear an applicant that is barred by res judicata. To do that, however, there needs to be a unanimous vote of the board members then present to reopen and hear the application. So it would be my recommendation that your first step is to try and get a factual inquiry of this board as to whether or not the current appeal arises out of the same parties, properties, facts, and relief sought as the appeal you've already determined. Secondly, does the appeal include issues and relief that should have been sought and the applicant had the opportunity to seek in their prior determination? The cases under res judicata don't allow an applicant to ignore res judicata just because they should have brought issues before the board at their prior application. The appropriate mechanism to do that would be for this board to vote and to rehear the application. However, if the board does not feel as though this arises out of the same parties, issues, facts, and circumstances, then you may determined to hear this appeal without it being a unanimous vote rehearing.
Joe, if I could ask, the question I have is, the chair just indicated, so what happened the last time was they didn't indicate what should happen. They left it to the building department. If this applicant is here, not to challenge the prior decision per se, but that's not on the table, but a subsequent conduct in effectuating, if you will, because there goes the building department. I don't think that was ever before the board before, because they just said leave it to the building department. I don't see how, my concern would be how you create immunity, if you will, immunize a building inspector. Obviously, they'll do their best job and try to approach it, but they are now just carrying out. So you're into a different thing. You're not into the underlying determination, which is the subject of an Article 78. You're not relitigating that. But if someone now goes to deal with it, they weren't denied the right to seek variances or seek argument about what they needed to do. That was left to them to work out with the building department. They can't agree. I don't see how res judicata says forever in the future, you're barred. I mean, it's not the same issue. I'm drawing a line between what has to be addressed after the decision versus what's before. It's sort of like when you have a determination in a judicial matter and then you work it out, or else you come back because no, there are new issues. So to me, it's like the applicant, I think he got a letter. I saw a letter in the record saying you want to go to the boards or what do you want to do? So I think it's not, if he was purely here to say I'm challenging the prior decision, that's one thing. But I don't think he's deprived as a person, as a citizen, or of anyone else, of the right to say, well, here's the way I would like to resolve it, and here's why I think it should be. That's my initial view.
Yeah, I would say that it is. I would just say that that part is the board's decision, right? That's a factual inquiry. However, if the relief being sought from the applicant at this point would be in essence, and this is something for you all to consider, would be in essence a overturning of the prior determination, then you get closer to the issues of res judicata. And also if you want to discuss risks or anything else, we can also go into attorney-client session. If you guys don't feel as though something's appropriate to speak here, let me know. I leave that up to you.
I have one. Wait, David, I was wrong about something. I know we discussed not saying, telling the applicant how to correct it. It's not in the resolution. There's nothing in the resolution.
But I went back to the.
No, there's nothing that tells the applicant what he's supposed to do.
Exactly. I'm just saying it's neither way. It doesn't happen either way. So it's not like we said we're not going to. There's nothing in the resolution that
It
tells.
may not be in the resolution, but if you go back to the hearing,
But there were lots of things in the hearing.
Sorry, excuse me. I actually asked when you were writing the resolution, I pointed out, you're not putting any remedy in there or any guidance.
Right.
And your words, because I went back and listened to it, Robin, was, I don't think it's our job. And he didn't ask for it. And then our attorney said, we are going to leave it up to the building inspector. So it's, to me, you decided not to do it. And you were making it sound as though that would be another decision. That would be additional work to decide what the remedy was, and you were choosing not to do it. So to me, that helps to define the fact that this is another action. I don't think the facts are the same, because we're not being asked to go back and look at the facts that were brought to us that he thought it was not a dwelling unit. He thought it was just fine. We're asked to look at the facts of what the building inspector is asking him to do. Those are new facts that were not there before. He has not asked for relief from the original opinion. He is asking for relief from these specific alterations or changes to his building. So he's asking for, I guess, some relief from that, but that's a different relief than saying, please tell me that I didn't make a separate dwelling unit.
Okay,
So,
but you,
Charlie,
but you,
sorry, if I could
sorry. Yeah, I thought you were done. Sorry, go ahead, Meg. Sorry, I thought you were done.
I also find, because I don't understand how, if an applicant is not allowed to then ask for an appeal of this administration of what was the determination when there was nothing specific in the resolution. It seems really that you're really barring his due process because, as I understand it, you have to exhaust all appeals before you go to another court. And if it just stops with the building inspector, we are giving him absolutely free rein. I mean, sorry, Frank, I'm not saying this is in this case, but the building inspector can ask him to do anything whatsoever, and he has no means to appeal it. That doesn't make sense to me. And one last thing is I went back and looked at what this board did for AVC Corporation. In AVC Corporation, the board found for the petitioners and not for Mr. Castaldi. And a year later, he came to us with an appeal for the fact that the building inspector was bringing him to court. And he was appealing that move by the building inspector. And we heard that appeal. It was based coming out of the same resolution for something where it went against him. And it was for an action that was then taken afterwards to administer that decision by the building inspector. And we heard that appeal. So I don't know why we would not appeal. I think it's not quite the same that he hasn't brought to court, but there was a resolution. The building inspector took some sort of action. He's appealing what the building inspector is doing. And we did that for AVC Corporation. We heard that appeal. And I think that we should be doing the same here in this instance.
I think that you just said something, though. That's interesting. That's an interesting analysis. I can't disagree with that, but you said something that does give me pause. You said that when you were listening to it again, we pointed out that he didn't ask for a remedy. Okay.
You said that. We didn't all say that, and you didn't say it in the resolution, so it's not an.
I understand that's not, but Ned, you can't have it both ways. You can't say we didn't say it in the resolution, so now we can talk about it. And he didn't say it in the resolution, so we can't.
I was just saying that you said you were not going to put it in there. To be very clear, you purposely did not put it in there. You definitely said we are not going to put it in.
I understand that.
That's it.
I understand that part. I'm not arguing with that.
And then you argued that he didn't ask for it, but that was you alone said that.
Well, I alone said the other thing too. So don't say that just because I alone said it, that means or doesn't mean it. My question is, if he asked for a remedy or didn't ask for a remedy the first time, and I don't know if he remember now, I don't remember if he did.
He actually said in the application, Robin, that if this is not going to go his way, he would want a variance. And then you said he didn't do that properly. But that certainly sounds.
Could you wait until, you know what? It's good that you're saying that. Now let me say what I have to say. If he didn't ask for a remedy the first time, and I don't remember if he did, and I don't remember if he didn't, so I have no idea at this point if he did or didn't. My question is, if he's asking us to provide the remedy now, but I guess that's not what he's asking, but he's not really asking for an interpretation either. I guess he's if we take it not as what he said, because he called it an interpretation, but we take it as what Meg says he's asking for, which is an appeal of the decision of the building inspector to enforce our resolution, then that may be something that we could consider as long as there's no res judicata issue involved. And I have to think about that.
Yeah, Rob, if I may, I'm sorry, were you finished? I didn't interrupt you, please.
No, I'm done.
Okay. I think it's obviously, you can't relitigate that issue here. That's a verboten. You can't do that. That's not our function. He is relitigating, he's litigating that, if you will, in the courts. But the effectuation of what to do, I have no trouble with. And I'll give you an example. For example, we just had CHOP on, right? They had every right. I think that the flavor of the board was they were getting denied. So maybe what we should have done was said, no, you're denied. And then they come back and say, oh, you can't come back for anything else. Of course they can. They can find a way that they think will accomplish their goals. That's what they are doing. We actually, and I think we actually suggested different things to them because they engaged us in that. I think he can't relitigate it. But if he says, okay, to correct it, here's what I want to do, I don't see how you can create immunity by anyone is like, they can make him do anything. That's ridiculous. That's a due process issue. He has the right to say, hey, I want to correct it. I'm going to comply with it. And here's what I want to do. I want variances or I want this. And what they're making me do isn't proper. It doesn't effectuate yours. I'm entitled to ask for a variance or ask for things. I think it's factually very sensitive, Charlie, as you, I think, mentioned. I think it is a factually sensitive issue. But I don't think you can take the bait and get into taking the original decision away. But I think you can get into a review of what's necessary, just like we said with Chop It. What's necessary? How could you accomplish it? Whether it's a door or otherwise. That I think is fine. I don't have a problem with that. There are new facts. It's not a res judicata. There was no decision in the past. Now there's a decision in the past that's binding. So those are the determinations made. His ability, it's like if you deny someone something, they have a right then to come back and say, okay, yeah, you're right. Now I need this, or I want to do this, or I want to do that. I don't have a problem with that. Unless I think it's just a circular game, but I don't see that. I certainly don't know enough. Maybe it is, maybe it isn't. So I think the caveat is, and I concur with you, Charlie, I think the caveat is, yeah, it is. You can't relitigate the issue that was decided. But how that gets played out and the impact of that, I think is fair game. It's not a matter of, okay, anything that the building department wants, anything that this board wants, no, you can't do that. It's got to be properly to effectuate that. We basically, as I read this decision, this board basically said, no, you're in violation. Okay. Well, he's here to try to correct it. And he may have one idea or another. As long as he's not going in to say, listen, I really was screwed because I shouldn't have had to do this. You do have to do this because that's the determination of the board. How it's effectuated, to me, that's the whole new process. And I think that's why we generally don't put ourselves in this spot. We generally do what we did with Chop It. Because candidly, in my opinion, Chop It could have made a motion right then and there. Because in my book, that was a no-brainer. They didn't qualify for that because of their counter opening, whatever you want to call it. But no, we went further. So, all right, you made your first decision here. And now I think you have to just see it through. You can't leave this. You can't just turn it over and say, well, whatever X, Y, and Z says. That's my view anyway. Sorry. Don't mean to be so long-winded. It's the evening and I'm tired.
All right. I take it now, Mr. Woods, you represent the applicant?
I do, Madam
Could you
Chair.
please identify yourself and proceed from there?
J. Justin
Wait,
Wood.
hold on a second.
I would just, the board probably should, you've discussed this issue of res judicata. You've kind of discussed it a little bit, but I think it would be incumbent on the board to make a motion just so we have it on the record that this application is not barred for X, Y, and Z, and then hear the application just to make sure that that issue is.
Should not be heard on that.
Counsel for the applicant to be a part of this discussion?
Yeah, can't the applicant be heard on that?
Oh, absolutely. I just didn't know if you were actually going to entertain a discussion on the actual application or the res judicata issue.
But Charlie, if we were to hear, and we'll hear the applicant's counsel, obviously, but wouldn't it also be that if we found that it was factually dependent, because it's hard to tell what the result will be. Because if the presentation ends up, we might conclude and say, wait a minute, you're doing an end run by wiping out our decision, or maybe not. So I understand what you're saying and I concur with it, but there may be a caveat in that if we might want to defer that and say, well, you go forward a little bit because see if you fall into the trap. Is that improper to wait then and hear the facts? If we
That makes sense. It makes sense to me because if the applicant presented and filed an application, which is a little confusing from my sense, it's a little confusing as to what he's asking. And I think that when they finish their presentation, we should make the decision that you're asking for. If when the applicant has made their presentation, we think that it is in fact res judicata, we can vote that way. If when the applicant has made their presentation, we think it is not res judicata, then we can consider it. I don't know that we have to decide.
Yeah, that's fine. I just wanted to make sure whether it's now or later that the issue of res judicata is dispensed with or upheld.
Okay. Okay,
Oh,
Mr.
thank you.
Woods,
Very helpful, Charlie. Thank you.
Mr. Woods, if you would, sorry, start again so we could,
Thank you, Madam Chair. J. Justin Woods, the law offices of J. Justin Woods for Stuart Teekert. And I apologize for interrupting you, but I felt you were debating really where I wanted to start, which was addressing what the application is so that we could move forward. We are not here to address the issue that you've already found to be that there was a pre-existing non-conforming use that had been altered inappropriately. That issue is the subject of an Article 78, and we believe we'll probably be back here to address that issue after the Article 78. But that's not what we're here for on this appeal. We're also not here to address, the long history of activities that have occurred with the building department and my client for over many years with him and the building department specifically, but other municipal officials. Those are also be subjects of other matters. This appeal is about what the building department said was necessary to bring the non-conforming alterations to the pre-existing use into compliance. The building department issued 7 directives to my client in order to do that. Those specific directives are the subject of this appeal. For the record, there's a, excuse me, and and in terms of Mr. Spalzino's letter about there not being facts in dispute, I think there's a lot of facts in dispute, and ultimately that's why we're here, and as well as litigating in other places. But there are some facts and some documents and records that I think materially affect or could affect your decision. Mr. Teekert had sent an email to the building department outlining half a dozen documents that are in their possession that should be part of this application. There was a correspondence from Charlie back to him that he could foil those documents. I don't think that a foil is necessary to ask the building department to put something in their possession that is germane to an application into the record with you. I think the standard in the public officers law is that to the extent practical, that stuff should be included in the board materials as well as on the website. And I don't think there's anything impractical about Mr. Teekert asking for those documents to be included in the record so that you have a full record to make an informed decision based on. I think that's consistent with the spirit of the Freedom of Information, the public meeting, and the open meeting law. And it's also consistent with ethical planning and ethical public administration. And you guys are in the council, manage a form of government, so we'd expect those standards to apply. And I think not doing so and the frustration of that we saw in that simple request, as well as the really the potential to not hear this different request is consistent with a pattern of hostility and retaliation against my client for participating in the democratic process of the community and advocating for himself and other issues. As it relates to the 7 issues, we can go through those one by one if you'd like. But I think it really comes down to the appeal and the request, a couple of different options for a clean and correct resolution. One option is to, as Mr. Teekert wrote in his correspondence to both you and the town board, is to stay enforcement, which is permitted under village law, pending the outcome of the various appeals processes. There is no danger to the health, safety, or well-being of the community in doing so and letting that process play out first. In the alternative, what he suggested was that he could bring forward a variance application, which is also a permissible resolution. I think Charlie raised some important questions about whether they're area variances or use variances, and and we haven't prepared that application yet, so I can't speak to that specifically at this point. But there's kind of 3 pathways forward. One pathway is getting into the details of the specific requirements that, that Frank laid out, some of which are subject of not appeals to the zoning board, but appeals to the state code office, which is also pending. Number two would be to stay the enforcement pending the outcome of the various litigation. Or number three would be to entertain a variance application that would possibly resolve these matters. And we're open to going down any one of those paths that that the board sees as most reasonable. And I think we're looking to have a conversation with you, much like CHOP did. Maybe it won't take as long, but what is the best path for this, that this board sees to work out a amicable resolution? And then we can go from there. You tell me which path you guys want to go down as a board, and that's the path we'll go.
If I could just, you referred to a letter that Mr. Gottlieb sent your client. Did we get that? Do we have that in our file?
Yeah, I don't
I
think
can
it was,
clarify it.
it wasn't an email to the board. There was some debate about what should be included in what was included in the application. And, you know, I don't think it's a
So I
big
can-
issue. It can,
But just
I can-
to clarify
I can-
something on
Well-
the application, on the applicant, we don't, the board and the board staff doesn't figure out what's appropriate. What the application consists of historically is what the applicant presents. The staff doesn't say, oh, we think you need this. The board sometimes says, so to the extent that you were asking the staff to determine whether these things were appropriate, that's not something the staff
that's absolutely
does.
not what I said, ma'am. Madam Chair, what I said was that my client identified documents that are in your, in the building department's possession that he felt were germane to his application and asked them to be included in the packet. That's what I said. That's far different than asking the building department to comb through their records and determine what should be included. My client determined what should be included. He knows what's in your possession. He knows which permits he's had and what he submitted to that department. And he asked them to submit it to the application. But that's a tangent, and it's not focused on what the pathways are. Really, let's focus on what those pathways are, and we'll go down the right path.
I would like to just provide clarification for this board. So I represent the ZBA. I don't represent the village. I don't represent the building inspector. Mr. Teekert emailed myself and Amber, and I don't recall if Ashley was on there, saying, I have a pending appeal. These documents X, Y, and Z, I feel as though are germane to the appeal. New York Village law for an interpretation request says once an appeal is made, the person who granted the determination being appealed should forward relevant application materials that are germane to that appeal. That is not incumbent on the Zoning Board of Appeals. Mr. Teekert asked that the Zoning Board of Appeals obtain that information. So my response said there would be 3 ways to go about getting that information before this record.
And they were all correct.
The ZBA could request it, and that would be perfectly within your jurisdiction. Mr. Teekert could ask that the building inspector include it in the appeal. That would also be very appropriate. Or you could do a FOIL request. So that was my response, and I'll forward you guys the email that I sent back, just so you have it in the record.
And Charlie, I don't agree. I don't disagree at all with what you said, your characterization. I agree with it fully.
Given that what Charlie said isn't exactly what you said, Mr. Woods, earlier, I think that I don't have a problem if the board members are okay with asking Frank to provide something to this board that was previously submitted into the record. Does that work for Meg, Greta, and David? Does that work for you? Asking the building inspector to provide the information that Mr. Teekert had requested, or Mr. Woods had requested. I don't know who requested it.
Mr. Teekert had requested it.
Meg, Greta?
Definitely would want to see those materials.
Sure.
So we have to ask the building inspector. There's no other way for us to get it. It's not in our records. It's in the building inspector files. So then, yes, so you agree that we should ask the building inspector, Meg and Greta?
Yeah.
Okay, so Frank, if you would please find out whatever those, if Mr. Woods would please submit to I don't know, Charlie, do you have that list of documents? that he
Yeah, I
wants?
have that list, and Justin, if that list is what you're looking for, I will forward it to the board and to the building inspector.
All right, so Frank, if you would get that for the next meeting and time, ahead of the next meeting so that we can look at that, it would be appreciated.
Will do.
Thank you. Okay. We have not, so going to your, so I'll give you my view on your three requests, Mr. Woods, right? You said stay enforcement, deal with the variance, or I didn't understand why the third one was relevant. That was about the state code. I'm sorry, I'm not understanding how that's relevant to us.
So the three paths were to get into the specifics of the seven, but I just wanted to highlight that some of those issues are not the jurisdiction of the zoning board of appeals, but they're subject of an appeal to the state codes office.
Some of the
So-
7 items?
Yes. So,
Okay.
so some of those are pending other appeals. You have jurisdiction over the certain decisions, and the code office has certain discretion to hear appeals of certain building code issues and electric code issues.
Can you please then delineate for us which are the things he is asking you would be asking this board for relief from, right? That's what you're here for. You are here to ask this board to interpret which of these 7 as we can, right? To determine if we can interpret or revise some of these 7 requests by the building inspector in some way, right? That's what you're asking for, correct?
Well, I think what Mr. Teekert asked in his January 16th letter to you, which is part of the board package.
Excuse me, I have a request to make. Mr. Teekert seems to send a lot of material to this board that he never sends to me. I only get it because Greta, having recognized that, forwards it to me. If Mr. Teekert or you want to submit anything to the board, please make sure that they submit it to the board in the way, which means to the village planner, which is how submittals to the board are supposed to be done, rather than sending emails to what ends up being only some members of the board. So if you would please.
Submitting an application or application materials will go through the planning department as they should. I didn't submit this application. I'm here to.
I understand, but I just want to make that clear, because even though we mentioned it before, it hasn't happened. So I want to make sure that in the future this does, and we don't have these problems of and I don't know if anyone else doesn't get, I don't know if Dave gets or not at this point directly from the applicant, but I never do.
What I can tell you, Madam Chair, is that anything that I submit to this board will go through the planner, which I have plenty of affinity for as
Great.
a 15-year planning director before law school. So.
Great. Okay, so I'm sorry, just wanted to say, so yes. So you were saying.
What I was saying was that in the January 16th request to this board, I think that Mr. Teekert was pretty clear in his request that there be a stay of this enforcement as it relates to letting the other appeals issues address themselves, that there is no detriment to the public well-being, to the health or safety of the community, as if that stay were to be in place, the enforcement stay were to be in place while those appeals processes, both the Article 78 and the codes appeal, work their way through the system. And in the alternative, if that stay is not granted, then we can evaluate if the variance application is the right form to request immediate relief.
I'm happy to give my 2 cents first, which is I am not willing to grant, and the rest of the board may want to. We haven't granted a stay in any other prior Article 78 proceeding. ABC were very clear we weren't going to do it. I see no reason to grant a stay of enforcement now when we've already decided what he's doing is the village board decided that the way Mr. Teekert was operating his property was in violation of the code, and I see no reason to stay enforcement of that while he litigates it. I don't believe, I believe he could have, but I don't believe he did ask for a stay in the court. I could be wrong, I don't know. But I see no reason to grant a stay. We haven't done it before, and I don't believe we should be doing it now. That's my 2 cents. So that's my short answer on the stay question. The rest of you can discuss it, can say your points.
Has a stay been requested elsewhere?
AVC asked us to do it, I think.
No,
And
no,
we didn't.
talking to the applicant, has this, we've done them in the past with someone else. But has the applicant requested a stay in the Article 78?
I don't know. I haven't been retained on the Article 78. I'm working in other capacities. Mr. Teekert is on the line, I believe, if he wants to address that question.
Would he please? Mr. Teekert, are you there?
He had been on the
I
Yes,
see him.
sorry.
He's there. He's there.
Good evening.
I'm sorry, I was fumbling with the Zoom. In the original Article 78, there was not a request for a stay?
Okay. David, did you want to have anything else to say? You got your answer on that one.
No, it's fine for right now.
Okay.
Is there some reason why, because it's an Article 78, that we would not allow a stay?
Yeah.
He's appealing the building code as well, and there is the Article 78, and there is no health and safety violations. So what is the reason why we would not grant a stay? Yeah, Charlie?
If I just may, just something to consider for the board. So the stay under village law is an automatic stay. So it's nothing that is granted by someone or something.
Then
There
if it's
is
stayed, then why are we
the
here?
notice when the notice of violations for the prior matter were appealed, there was an automatic stay. Nothing ever had to be granted until that appeal was resolved, right? So now, the board should consider whether or not there should be, whether there is an automatic stay for the current appeal, which appears to be related to the remedy. Another thing that the board might have the applicant look into or our office look into is the enforcement powers of this board, right? Because the notice of violations that are at issue in the Article 78, those are now in the hands of the village's enforcement department, the building inspector and so forth.
Can you just stop and answer this? So if the stay is automatic, then the village building inspector shouldn't have been enforcing the resolution, or let me go and find out, because if I understand what you just said, let me take it. If there was an automatic stay of proceedings, should the village building inspector have been enforcing the resolution that was appealed from, or was that automatically stayed and all of this should just be moot and therefore we can go home on this? Or is
The
that something
stay-
different? I'm confused now, because
sure.
that sounds like it was all automatically stayed, and so enforcement should have been stayed, so the building inspector should have been stayed, and we're done for the moment.
So when there was an appeal of the notice of violations, there was an automatic stay.
Of
that
what?
automatic stay of the notice of violations that were appealed.
Okay.
That automatic stay was lifted when the ZBA issued its resolution. The applicant would have had the ability to seek an automatic stay as part of the Article 78. It doesn't appear as he did that. That's not a matter for this board. If there is an automatic stay here now, it would only relate to those determinations that are being appealed. It would not apply to the notice of violations that have been issued prior and that have been resolved.
So there is no, so you said something about automatic stay, but that's not relevant to anything now. If the automatic stay only applied to the violations, and he's not appealing per se the violations, he's appealing the building department's interpretation or enforcement of our resolution, it's a completely different matter, and automatic stay isn't relevant to anything. This is what
Aren't we staying what the building inspector required? Now he's appealing that, so there's an automatic stay for the building inspector to enforce those requirements.
While we're pending it, is that what you're saying? Is that all you're saying? Yes, while we're considering it, there is always a stay.
So here's the question that the board needs to decide. He's appealing the remedy, right? And this all goes back to the res judicata issue. He's appealing the remedy. That remedy is not an enforcement action. The notice of violations were an enforcement action that was then stayed by the appeal that happened back in 2020. So there is no enforcement related to what they are appealing now because it's not an enforcement action. That is something.
Except that in the resolution, there was no directive as to how to enforce it. So I don't understand, like, and then how to enforce it became what was the remedy that Frank gave. So I don't understand, like, that can be enforced, and yet there was no information in the resolution on how to enforce it. And Frank did that in the letter that's now being appealed. So
and that's what's being appealed, is the interpretation on the enforcement. And I think that there's other factors that weigh in on this as it relates to the building code appeals as well as the Article 78. So, we would be content with simply requesting an adjournment pending the outcome of those other actions. And then I think we would have clarity on the path forward. Or in the alternative, we can bring a variance application and we can go that way while those other remedies work their way through the various processes.
Madam Chair, may I interject?
Yeah, sure.
First of all, I think what Mr.
Wait,
Gottlieb-
excuse me. You need to identify yourself for the record, please.
I'm Robert Spolzino. I'm the village attorney. I believe what Mr. Gottlieb said is correct, that the stay is not a function of the board exercise of any discretion or determination by the board. It either is a stay, either is a stay or is not a stay as a matter of law. And that would be determined should the village decide to pursue enforcement action. Mr. Teekert could defend that enforcement action on the ground that it stayed, but it doesn't require any action by this board one way or another.
So going back to, so there is no currently, so just going back to, I'm trying to make it very, so understanding, because I kind of, the stay that was against the violations is moot now because it was ended when we issued a resolution, correct? That automatic stay that was in place during the pendency of his appeal is over. That's moot, doesn't matter, who cares? It doesn't matter now because we issued a resolution, correct?
Of the pre-existing non-conforming issue, that's correct.
That's correct.
Fine. Okay, so there's no, okay, so now the building inspector has sent out some correspondence with the
Remedies.
applicant as to how to comply with the ZBA resolution. And it is that, so there's no stay related to that because it's an appeal. It's a separate appeal, separate question. Whether it's res judicata or not is irrelevant to this question. It's not the same question, right? There's no stay involved in that, right? That's a separate application. Yes, Charlie, yes, I understand that you're saying Mr. Woods, but I want to know that our counsel are saying, Charlie.
Yeah, you have it correct.
Okay, so then everything about a stay is sort of moot because there is no stay, period. I don't know why we're discussing a stay. There is no stay.
There's an automatic stay. There's an automatic stay in effect right now on the 7 conditions in the letter that was sent out because they're pending this appeal.
Correct. That's the, yes. Okay. So there's.
I don't necessarily agree with that, but I don't think it's a decision for this board to make one way or another.
Correct.
Okay. So
it would be this board. It's a stay by operation of law. It would be up to the village enforcement office to either think there's a stay or not think there's a stay and pursue enforcement. That's not of a ZBA concern.
Okay, so then it's the only reason I'm trying to get is because both of you, Charlie and Justin and Mr. Woods, all talk about this stay, but really the stay is irrelevant to us, right? right? It's irrelevant to us. There is an automatic stay by operation of law against the enforcement of those 7 conditions. That happens regardless of whether we do anything or not. I mean, I assume there's things we can do. We can say, we could do something that would end it. But other than that, that's not relevant to our decision tonight or not, or next week, correct?
As I said, Madam Chair, I agree with you that it's irrelevant, but I don't agree that there is a stay, an automatic stay, but it's not a matter for this board either way.
Okay.
Either is or it isn't.
Okay, so not relevant to this board, which is all I'm interested in. So let's move on from, because one of the things, Mr. Woods, you said you asked for was to stay enforcement. We don't, so you're asking that as something separate. You're saying you would like this board to tell the building inspector to make a decision that we should stay the enforcement of the resolution pending the decision in the Article 78. Am I correct? Is that what you're asking?
What I asked the board to do was to adjourn the application pending the outcome of these other processes.
Which results in an automatic stay, because if it's adjourned, it can't be considered. Okay, I got it now. That isn't exactly, I don't think, what was asked in the application, but I guess you're asking for something slightly different. Okay, that's fine. Now I understand.
So the position of the village on that, Madam Chair, would be to oppose that application because you've already determined that there's an illegal apartment. And to continue this proceeding while these other proceedings are going on would be to allow an illegal apartment to continue.
There's no health and safety violation. And he has.
There is a health and safety violation because you have someone on the 3rd floor that shouldn't be there.
I'm sorry.
Shouldn't be stayed.
I'm sorry.
Go ahead.
During the resolution, the code enforcement officer during our public hearing said there was, I'm sorry, I don't mean to be discussing facts from the, so stop me if I'm doing something wrong, but there was no health and safety violation that was brought up then. So it's a zoning compliance situation. It was not a health and safety violation. So I don't understand why, if it's not, it's not affecting anybody else in the village, not health and safety. It is being appealed. It isn't being ignored. It's being appealed. It's going through the processes. It's going to the wherever you appeal in the building code. It's going to the Article 78. It's this appeal. So it has not been ignored. Why we would think we would push and think it's so important to act on this rather than to allow it to go through the processes, I don't really understand.
Please don't misunderstand, Ms. Yergin, what I said. I'm not suggesting you not go through your process. I'm suggesting that you not delay your process, that you proceed and make a decision one way or another.
Now, Meg, in answer to your question, I have a different view. We determined that he was doing something illegal in his property. While it may not be dangerous or unhealthy, right? Not a danger to health and safety. I agree, presumably, I don't know, but we didn't decide that. I'm not making a decision on it. Let's assume, just for argument's sake, it isn't a health and safety issue. It is a violation of our code. I don't see why we should grant a stay of enforcement of a resolution that we adopted simply in order to allow it. We made this determination. Our argument before in the Article 78 is the applicant is wrong. So if we think the applicant is wrong because we came down with this resolution, why are we saying, let someone else decide it now? We already made that decision. I think we enforce our decision, and we enforce our decision by continuing on the process. We don't adjourn it. We don't give it a stay. We just continue it and we make a decision. And if the application and if he's appealing those 7 things, then to the extent those aspects of those 7 statements are something within our purview to consider, then we can consider them and reach a determination or decide, no, he needs a variance, which in my view would be a use variance because he's asking for a use that isn't permitted. But whether we decide as a board it's a use or an area isn't the issue right now. So I see no reason to issue any kind of a stay. We made our resolution, and I see no reason to not make the village proceed with its normal process of enforcing it, even if that means that we have to reach some determination on what that means or how it operates.
Yeah, well, we have issued stays in the past, I know that, and involving some subdivision problems. What would be could someone explain to me the harm that would come to the village aside from allowing the continuation pending the outcome?
Well, then why bother making any decisions? If we're just going to stay everything, why don't we say we just don't have to make a decision? We'll let the courts decide everything.
Because stays are given all the time, sometimes, and so therefore, and they're given by people sometimes after they rule against people, because the idea is, okay, so effectuate your appeal, take your process, and see where it goes. By your standard, then everything, no, there wouldn't be any stays. I understand that, but
I didn't say that.
But
I
I'm
said
asking
that-
the question. My question was not to you, unless you know the answer. My question is, would someone explain to me the harm to the public, the harm to the village, other than the fact that I understand there's a violation based upon a determination, and that determination is being reviewed. So I'm just trying to understand that. That's all.
Well, from my perspective, the harm to the village is continuing under an illegal situation.
Appreciate. Okay.
I don't know who else is going to give you an answer. Meg will give you her answer,
Well,
and
I'm
Greta
trying
will
to
give you
ask
hers.
I'm Mr. Spalzino is there. The
I'm here.
gentleman is there. Thank you.
So again, Mr. Neufeld, the harm is the continuation of the illegal apartment, but I would just reiterate what I said, that it's not up to you to either grant a stay or deny a stay. The stay either is or is not. You can decide if you want to adjourn this proceeding, that's up to you. But whether you grant a stay or deny a stay is not up to you. It's a matter of law.
But if we grant a stay, if we grant an adjournment, we've effectively stayed the enforcement.
That's correct.
Right, so it gets you the same
Well,
place.
I know, let me
I want to remind the board
there
how
either is a stay or is not a stay. Okay, you've effectively delayed a resolution of the matter.
I remind the board that when Ralph's was determined to be an illegal, didn't get a special permit, it was operating with the outdoor counters. It was given a year and a half to try to work out a situation. It was allowed to continue in that situation in order to work with the applicant.
Forgot about that one.
And I know that's a different situation because it was a poor decision on the building department to let them open. But here we have an applicant who has been doing the same thing for 30 years and showed that there was another building inspector in the area. We don't know all, I'm not going to re-argue it or something, but no one else has complained about it. Nobody else is concerned. Why we wouldn't extend the same sort of courtesy to try to work something out before action is taken against it, simply because it's a non-compliant action. When it's not in any way affect anybody else in the village, other than the fact that it's continuing on in a non-compliant fashion. If somebody had built a huge deck and put a lot of money into it and really asked for some time to figure out another way to do it, I don't know why we would not just say, oh, no, it's not code compliant and we made the decision, so you got to rip that thing up right away, rather than trying to let it go through appeals or to try to take some time to figure out the best way to remedy it.
But you see, you're asking, it's two different things, Meg.
That's it.
If he wants to be here to ask us how he should enforce it, that's okay, right? If it's not a res judicata issue and he's really asking us to figure out about the enforcement and how we think it should be enforced, that makes sense. That would be equivalent to what we're doing with the Chopped and with all these others. We're trying to work out a way for the applicant to get what he needs. It's not adjourning it. We're not saying, we never said to anyone, and we wouldn't say to anyone, we're not going to consider this application for months while you figure something else out. We make them come. We make them appeal to us. We work with them. We figure out how we're going to do it. So that may be the way to resolve this, but adjournment just to let it sit, because I don't agree with that. I don't like that. We haven't done it. I don't see a reason to do it. And that's not what, and none of the equivalent situations you've been mentioning would have been the same thing. We're working with them. So if we want to, as a board, consider how to remedy or to enforce, or not, we're not considering how, we're looking at what he applied for what the village building inspector, and to the extent we can consider it, we decide whether that made sense or that works or that's a reasonable way to do it. That's fine, but I do not like the idea of just adjourning it so that it's really an effective stay, even if it's not.
Meg, could you clarify for me what stay we're talking about? Because there was a little, I just want to clarify that. We're talking about the stay on the applications now?
I'm sorry, are you directing your question to me?
Yes, I am, yeah.
I'm sorry, can you?
Yes, what stays are we talking about? Because I got confused on this now. We have.
As I understand it, we're not talking, it's not within us to stay anything, so we're not talking about a stay. We're talking about whether we're going to adjourn this process right now, which in a sense puts it in a kind of in a state of stay, because
Suspension, state of suspension.
suspension, while, and I believe that what Mr. Woods was suggesting was while it goes through the appeal in the
In the 78.
appeals in the building for the building code violations, and the Article 78 makes its way through the court. We hear what the result is there.
Because quite frankly, a large part of what's in these 7 items is not a zoning issue, and it doesn't all weigh in on the issue that's being litigated in the Article 78. And some of this is not zoning stuff that is in your discretion to interpret, even though you have the authority to interpret the building official's decisions. And I'll give you an example. One of the things says remove base kitchen cabinetry and countertops. That's not a zoning issue, and there's many houses in that have more than one kitchen, that have an entertainment kitchen in the basement going out to the garage, has another kitchen. So that in and of itself doesn't make it isn't necessary to effect the fact that that doesn't tie back to what the interpretation was, which was that there were alterations made that extended a non-conforming use. Another good example is that a doorknob has a lock on it. Many doorknobs have locks, even when there's roommates. It's routine, especially around colleges, especially with people who own homes who have a roommate that they still allow them to lock the door. Those things aren't unreasonable, and those issues are what the subject of this appeal. But your ability to make a fully informed and accurate decision is going to be impacted, number one, if the Article 78 plays out differently, but also based on what the interpretations come back from the State Code Department, where these issues are under appeal.
I think that makes sense. I think we shouldn't, there are obviously other entities that are going to have reason to interpret this, and it's going to be more seamless for us to get that resolution and then make whatever decisions we have to make. We could be spinning our wheels, making decisions that we can't do, that a higher authority will overrule us. Adjourning it and waiting to get clarity makes a lot of sense, I think.
David?
I tend to think that I tend to feel comfortable with Greta, because I think in balancing everything, I just find that taking someone's property away, so to speak, and depriving them of this, and I understand that there's a violation, and there are many violations in this village, many, many, many. I've not been comfortable with seeing the background of this one, but certainly they're wrong and they have to be remedied. But the issue is that I think if this person's pursuing actively, as they are the 78, and they're pursuing the remedy here, I mean, it's a lot of added effort for everybody, as opposed to just seeing where it goes, so we know what's really ripe for review and not what's mooted out. And at the same time, and we've done that in the past, I'm trying to think of the name of that. That was that subdivision with the window wells and other problems.
That was the AVC.
Yeah.
That was the AVC.
Yeah, we stayed on that. I'm inclined I'm comfortable with Greta, because I think it's the way to go. But I'm not comfortable with just doing it endlessly. I think it's got to be kept very tight. And
Well, if somebody wants to make a motion, David, since you can make a motion to adjourn as three of you seem to be inclined to adjourn. I don't agree with that, but you know, three of you want to adjourn it, we'll adjourn it, obviously. So if somebody wants to make that motion with some time in there, I don't know, it can't be an adjournment forever.
it can't
So
be
if we're
assigned
going to
that.
adjourn, we need an adjournment that is with a date. And again, we don't have to have the resolution today. You would, I don't think we would want to make the motion. I mean, we're not going to vote on it. We'd want a written resolution before we voted on it. But I think if you want to,
It's the same thing. If you're going to adjourn it, it's effectively, it's a de facto, isn't it? De jure then, I suppose.
but I think if you're going to adjourn it, then we're either going to adjourn it for every meeting.
Yeah.
Until we decide not to adjourn it. Or I don't know how you want to do
Once the
this.
78 is returnable, what, the first week, next week, I believe, the 15th?
Stuart or Bob could probably.
I don't know. I'm not.
Yes, isn't that what we were told earlier?
Told the 15th.
Stuart, is that correct? Stuart, is that correct?
I'm sorry, what's the question?
What was the return date on the Article 78?
The date you have to respond to.
I believe it's the middle of February.
That was a reply date, or that's a court date?
Geez, I'm not up on these legal terms.
So I think that, Dave, to your point, I think it's well received and very reasonable. My thought would be that if there was language that had it pending the outcome of the Article 78 and or the code appeal, and that, you know, if either of those come back at any time, that information has to be brought directly back to you so that you could reevaluate whether there were still other outstanding issues or had all the information you needed to make this decision.
Two comments on this. One, the problem with adjourning it until the Article 78 is resolved is if Mr. Teekert loses, he may appeal. If the village loses, it may appeal. The Article 78 may not be resolved in the short term. That's the first thing. The second thing is we're going to just adjourn it until are you proposing we adjourn it until everything is resolved? That could be years. I don't know, but I have trouble with after we've decided that something is a problem. And with AVs, I have a problem with deciding that we just keep adjourning things ad infinitum. So, you know, I mean, I'm going to lose anyway because I have a problem with adjourning this at all. But it does seem to me doesn't even make sense. So.
Well, I would like to make a motion that we adjourn it. But I understand that we want to put some sort of time on that adjournment. So Dave or Greta, do you have an idea of a times, or are we just going to continue?
No, I would
review it at every meeting, whether we, you know, if we're going to adjourn it, and then we can decide when we want to pick it up and when it's been too long. And
I don't really want to have this on every single calendar, and every single calendar we open it up, decide what we want to do, and then do something else. If we're going to adjourn it, then figure out whether it's 3 months, you know, a time specific or an occasion specific, but not just this every meeting to meeting.
Why don't you do it for 2 months or the earlier of 2 months or a decision, and then we can get a report on how it looks in 8 weeks, maybe. I don't know, or 6 weeks. I don't know.
I'll make a motion to adjourn it for 2 months or whatever's earlier. If we get the decision on both the, I don't know, should I make it for the building permits as well? Just because they're wrapped up into this directive, even though that's not our jurisdiction.
Oh, we don't know. Are these
78.
On the 70? No, we don't know that.
Look,
we've adjourned things in the past for people.
Why don't we just do it for 2 months, and in 2 months we can then
Deal with
assess
it.
where we are, whether we want to continue to adjourn it.
Yeah.
Okay, so I make a motion that we.
Is there any, I have a quick question for Mr. Swift. Is there any action pending right now against the applicant?
Well, the violations from the original violations are, there's no stay moving forward with those. But to my knowledge, I don't handle prosecutions, But to my knowledge, the building inspector has not moved forward with those violations in the justice court.
All right. So Greta, what was that, for 2 months?
2 months, and then we'll see where we are. I mean, I doubt the 78 will be decided in 2 months, but
Probably not.
Well, we'll see the papers, we'll see what's going on. Right.
Yeah.
Okay, so I make a motion that we adjourn it
You
for
wanna do
2
90
months
days?
and review it.
We all know that it's not going to be back in 60. Do you want to do 90 days? So we don't have to do this fund. You can only do this fund once a quarter. Well,
See where you stand in 2 months. See what Mr. Ticket's, what the position is in 2 months. We'll get the 2 months will give everyone an opportunity to sort of clean the air and see where they are. I think gives him an opportunity as well. I think he shouldn't be sitting still. I think what's very clear is there are violations based upon this decision. He's got a 78 pending. Listen, he's free to go and get a 9-month stay from the court. That's not our issue. That's up to him. He do whatever he wants that way. All right.
Okay, you made a motion. Is there a second of Meg's motion so we can move this on?
I second.
All right, let's vote. Dave,
Yes.
Greta.
Yes.
Wait a minute, we don't have a written, oh, we don't need one. This is pretty simple. Meg,
Yes.
and I vote no, so you've got a 2-month adjournment.
thank you, everybody. I appreciate your time this evening.
Thank you, Mr. Sposino. Thank you.
Okay. Okay, moving on to the next.
I out here.
David, did you say you had to leave?
I do, yeah.
Okay,
Really have to leave at 6 in the morning, 5:30 in the morning. Okay. I'm
okay,
good you all to do. Thank you, Robin. Thank you very much.
okay.
Wonderful to be back, and I appreciate everything, Robin. Thank you.
All right,
I
bye.
mean that. Everybody.
Okay, well, we have 3, we still have a quorum, so let's move on. The next hearing, the next application is 526-530 Fayette Avenue.
Amber, can you tell the, do we still have Mr. Woods and Mr. Teekert on the?
Oh, yeah, you should get rid of them, please.
This hand motion is the Zoom screen.
Is that what that is?
That'll be the next thing that gets invented. You can do that by Zoom.
I'm on Zoom all day long at work and I use my hands so much. Like, I think it's because you think, do you really hear me? Like you're.
Yeah.
I use my hands less with Zoom than I do in real life, so, you know.
Oh, or maybe I
And to
just
the
use
extent
my
I'm
hands
using
a
my
lot.
hands, you can't see them. I'm moving my hands now, but you can't see them on the Zoom, so.
I just catch my other corner. I'm like, who is that lady with the thing going on?
Okay, so, okay, they're gone. Is Annie Klein, is she the applicant on 526 Fayette Avenue?
Hi,
Amber?
good evening. Yes, I am representing the.
Okay, stop. We have to open it. So let's start. Okay, this is an application 526 to 530 Fayette Avenue for an extension to the variance.
Yes, good evening, everyone. I will try to keep this short. We were here last year. We received a variance for parking. The applicant has 2 properties at 526 and 530 Fayette Avenue. The proposed project is to demolish the existing buildings on the site and build a 3-story commercial building in which his company will be the main tenant. So what ended up happening, unfortunately, with the pandemic is one of the buildings on 526 Fayette Avenue is actually the location of the applicant's current business. The property at 530 Fayette Avenue is a residence that is currently occupied by a tenant. And based on the governor's executive orders, they have been unable to remove the tenant from the property so that they can proceed with demolition and construction of the project. So unfortunately, that is still the current state of things. So until we are able to move forward with getting the building unoccupied for demolition, we are unfortunately have our hands tied here and cannot proceed with the project. So we are asking for another year for the approval.
Does any, Meg or Greta, do you have any questions? I have none.
Seems quite
Seems
reasonable.
reasonable to me.
Is there anybody in the public who wishes to address this application?
I do not see anyone who wishes to speak.
Okay, Meg or Greta, you want to, or I'll make the motion. I move that we extend this variance for another year from the expiration, that we extend the variance for 1 year from the expiration of the current variance.
I second.
Okay, Meg,
Yes.
Greta,
Yes.
I vote yes, this is extended.
Okay, great. Thank you so much. Have a good evening.
Thank you.
I'm not staying on for the EIS now. I mean, this is
We have
getting,
some time issues though with I think we have some real time issues. We have to have it tonight. Am I right? Somebody, Charlie or Ashley, Meg, did you just say you didn't want to stay on? I'm sorry. I'm assuming.
no, I mean, I don't want to go into a long discussion now, starting at 11:16.
Oh, yeah, absolutely. I agree with that. Yeah. Okay. So
And I wonder if but there's nobody else to ask if they want to, if we want to have a special meeting to do the work on the DEIS, trying to always put it at the end of a long meeting.
I mean, that's okay with me if we can find a date. I remember that was always our problem. Again, unless we have some time, and I believe we have some time issues, right? There's a time. They submitted the revised DEIS when?
I think you're muted, Ashley.
Thank you. Yes, we are running against some time issues. We received the revised DEIS on January 5th, and the board has 30 days to review and
Now,
provide.
I asked this once before, but I'm going to ask it again. If we don't review, if we don't decide it within that 30 days, is it deemed accepted? Or is
No.
it nothing? There's no, so we could, so there's no penalty for not deciding it.
So
So
there's no
there-
penalty, but I would say that you have received memos from AKRF as well as the village engineer. There were responses from the applicant on the village engineer's comments, and I've reviewed them, and I feel that everything that is outlined in both memos can be addressed administratively. I think they have addressed all the substantive comments that were raised at the previous meetings.
So I should say, we're discussing case 15A 416 Waverly Avenue, completion of the DEIS.
And I'm sorry, could you tell me again the date that you received the response? Was what?
We received the revised DEIS on January 5th, 2021. The village engineer sent out a memo today that had a couple comments on it, and then I received a response from the applicant a few hours after that.
My only thought on all this is,
I'm sorry, but just about the dates. We had a meeting in January. Did we review this? I thought we reviewed something in January.
no, December. We reviewed it in December, right?
And we didn't review it in our January meeting, is that it?
Right, we didn't. It seems to me that we issued it as my only concern. So we have really, I think, two choices. One, we determine that it's complete, provided they make these changes that both Ashley and the village building, that the village engineer found, or we don't determine that it's complete because there are still issues as raised by Ashley and the village engineer. My only thought with declaring it complete, provided they do this, is those have been the same comments. They can't seem to get them right. How do we know that they're ever going to get them right? And I'd be concerned with determining it complete, provided they get this.
So
Who makes
one
that
of this,
you know?
it would be delegated to your consultant. So we would ask for a proof copy that we would review prior to telling them to go to print. And just I mean, just to be clear, by declaring a document complete, you're not saying that you agree with its conclusions. It's merely saying that it's complete for the purpose of public review.
Right, but my point is that they haven't, okay, so let me just ask this question. Let's assume we say we're going to deem it complete, provided they fix all the things that the village engineer and you, and/or you, AKRF, said were problems. Okay, so they submit you a proof copy in 2 weeks, 1 week, 3 days, whatever it is, and they're not there. So then you send them a letter, right, that says it's not complete. So then what happens? They submit another proof copy, and they
Right,
keep
they
doing
would
that
submit
until
another
everything.
proof copy, and what would end up happening is if they don't get it in quickly, they would miss the deadline for the public hearing, because there needs
Well,
to.
okay, let me ask you this next question. What's the, just because we need to know all this, the timing for the public hearing, once we determine that it's complete, what's the public hearing timing?
So,
So
oh, go ahead, Ashley.
If you set the public hearing for March 4th.
We're
I'd
not
recommend-
setting the public hearing. I want to know if once it's determined to be complete,
It needs to be filed 15 days before the public hearing.
okay, what's our limit? Do we have to have the public hearing within 30 days, 60 days, 90 days, no time limit? What's
There
the
is
other end?
time limit. I think is it 60, Charlie? You know,
Yeah,
offhand?
so there's a public comment period, and that public comment period is 30 days minimum. Or 10 days after the public hearing, whichever is longer. I do believe that there is a 60-day limitation on the public comment period. You could have 2 public hearings, you could have just 1, which is quite typical. So what would happen is you would deem the DEIS complete. They would, and I have every faith in the applicant wanting to move this forward, that they would get it to Ashley likely immediately. She would then notify the board that it's sufficient, and then the notice of complete DEIS would get submitted, which is your public hearing notice.
Oh, but wait a minute, that doesn't answer the question. Let me go back and make it much simpler then. Let's assume, and I'm not as so sanguine as you about their ability, given that they haven't made some of these corrections over 2 iterations. I'm not convinced they're going to do it so quickly or so thoroughly. Let's assume they do. And let's assume they get it in to Ashley by the 15th of February next week. And she determined, well, that's the week after, let's say February 12th is next Friday. They get it in by next Friday and she determines it's fine. Okay. I don't care when we can have the public hearing. I want to know when we have to have the public hearing.
Within 60 days of it being complete, of being filed.
Okay, so what that means is, since I don't, and then board members, we have to decide whether or not we want to have a separate public hearing on this, or we just want to have the EIS public hearing as part of our regular board meeting. And I would say, given the number of people who haven't shown up on any of these applications, that we should just have the public hearing as part of our regular hearing. That's what I know that's what New York City does. I don't know what other villages or towns do, but when we have
it's highly controversial, they will have it on the regular meeting night.
Right, and that's right. So I would say we have, let me just finish, Meg, and then it looks like you want to say something. So I would say that it doesn't really matter that whichever one we do, assuming we decide to say it is complete, provided they correct everything, that at our next meeting, we schedule the public hearing for the April meeting. That's what I would say we should do. That would be my recommendation, but otherwise we don't have to have it in March. We could have it in April. We could have it in March if we were convinced that they were going to get everything in, but I don't know. So, okay.
And I just noticed that the applicant's attorney has their hand raised. I don't know if you guys wanted to hear from them or not.
We don't usually hear from applicants when there's no public hearing, but I guess on
That's fine. I defer to the board.
I mean, if you want to hear Meg or Greta, we could hear. There's no reason we can't, but it's up to you guys. I don't have any.
I don't want to extend the discussion. I was just asking for a sense of the steps now. let's say it's 60 days and you have the public hearing, and then how many days do we have? Our first decision would be on the secret evaluation. Is that it, before we even get into the variances and the other aspects of the application? Is that correct?
So what happens is, once the public hearing is closed, the applicant has to go back and prepare what's called a final environmental impact statement. And that goes through all of the substantive comments that were received on the DEIS, and they need to respond to all of them. They will submit a draft FEIS, as well as outlining any changes to the project that were done, and an evaluation of any potential impacts of those changes that were the result of public comments. Unlike the DEIS, the FEIS is the lead agency's document. So you will need to agree with how everything is characterized in that document and how all of the responses are framed. Once you've
In that
declared.
situation, that's not responses on whether it's complete or not. That's actually substantive judgments on what was there. What we
Yes.
is, okay.
Okay, so given what Meg just said, so let's assume it was perfect today in terms of completeness. When we're, and let's assume there were no comments in the public hearing. Okay, no comments in the public hearing, and it was complete as of today. So let's just say it was done as of today. Could our FEIS be different than this because we don't think they framed it in the right way, or because there were no comments, we really have to leave it this way? So I understand.
No, it could be different. It could be
Okay.
different. And usually, in most cases, there's some project changes that occur between the DEIS and the FEIS.
But if there aren't, we still could make changes in it. We don't have to accept exactly what they say.
That's correct. If you don't like the way that something's characterized, you can change the way that that's worded.
Okay, that was my question. Yeah. Greta, Meg, any thoughts on what you want to do? It strikes me that, since I don't really want to spend time, I don't want to talk about this anymore. And I don't know how much either of you have reviewed the last revision, whether or not you're satisfied with leaving it in Ashley and the village, Ashley's hands really, to make sure that it conforms with all of her comments, as well as all of the village engineers' comments, or whether you want us to have it come back to us again. That's really the question. Are we going to rely on Ashley to just review it and issue her and make that and determine that it's correct, or do we want it to come back to us again?
Ready
In
for-
terms of the harm, it sounds like we're gonna get another, we're gonna get another stab at the process to make substantive comments. That's correct?
Yes, this is merely saying that the document has all the information that was in the adopted scope, and it's complete for the purpose of public review. There's enough information there for the public to attend a public hearing and make informed comments.
And I will
And
say,
we can disagree with the substance of what's in the document.
Yes.
Correct. And I will say there is the secret handbook. I don't know if you guys have heard of it. And the secret handbook says the DEIS doesn't need to be a perfect document. That's why you have the FEIS process. It's an ongoing process. So that's what that's for. And related to timeframes, I do have a secret flow chart that I'll send to this board that'll be helpful, and it has the timeframes in it. And you can utilize that. So if the board does decide to grant the DEIS complete based on Ashley's final review, you should target a date for a public hearing on the same, so that notices can be prepared and so forth.
I'm sorry.
No, go ahead, Meg.
I just wanted to ask, so we can still make substantive comments. So if I feel that I have questions about how a test was done, or question the results, or why they chose to emphasize this and not that, that's not about the completeness of the document. That would come up, I would have that chance to say, I thought that this, I'm not convinced by that analysis for these reasons. I don't have to tell them now.
Absolutely.
Okay.
The completeness is only, there was a scope, Does the DEIS have what the scope said? And then you can make your comments during the comment period.
Yeah, okay, because I find as I keep reviewing, it's more the substantive stuff is what I'm making notes on. And so I think I'm ready to say that I think it's complete with Ashley's help in getting those loose ends tied up.
Okay, just from a processing question. So we have the let's assume at some point it's going to be deemed complete. Let's assume tonight with subject to Ashley's review. Then we have a public hearing. Okay. After the public hearing, they're going to prepare a draft FEIS. Is that what happens?
Typically, yes.
Okay, so that's what we would want. So that draft FEIS would then be another, sorry, but I need hard copy of this. This is too complicated to look at not hard copies. So we would get a hard copy, I think many of the board members would want, of the now new draft FEIS that we could then edit as, right?
Yep.
Yes,
correct.
but I
So-
would add that the substantive comments that Meg is referring to are things that you should bring up while the public comment period is open.
So it's kind of like one of our public hearings for our other applications. We're making our
Yes,
own at the same time. that we're
yes.
hearing the public comment.
Unlike a regular public hearing, the board is encouraged to have its own public
So we should
comment
get
in a formal
prepared
letter.
in the next hearing to make those comments. Okay.
Okay, so Meg and Greta, I guess it seems simplest for us to deem it complete, provided that they do make all the changes that Ashley has requested on the village inspect building, not the building, the engineer has provided as the term, as reviewed and approved by Ashley. Does that seem right?
Yeah, yep,
So was that a motion?
I'm okay with it.
No, I was just wondering if that works with what everybody's saying. And then we should also, I guess what they're saying is tentatively set a date for the public hearing. When would you like it, April or March?
Well, let's make it April.
That's my view. I thought April.
It's April, our normal April meeting. We must have a meeting already scheduled for April.
Yeah, like whatever that is, the 5th, the 6th, the 7th. I don't know what the date is.
Well, what you might do, and this is just merely a suggestion to try to keep the ball rolling, is set it tentatively for March. And if the applicant doesn't have the changes made to Ashley's satisfaction, then there is no public hearing and it's moved to April. Just a thought to keep the process going.
I'm just hoping that I get more time to review it.
Let's leave it for
I have to
April.
wait for an FEIS. We're waiting for something else, right? I'm going to be.
No, it'll be very similar to the document that you have right now, just with the minor changes that are outlined in the memo.
Okay.
So we're not going to get in terms of what we're going to have, they're not going to provide another document. Are they the complete DEIS?
They will provide it digitally. It'll be on the village's website. It'll be at the library. It'll be circulated to all of the involved and interested agencies.
Okay.
Right now, most agencies are taking it digitally.
Okay. Meg, Greta, April or March? I'm happy with April, but if you want to move it to March, I'll go with March too.
I prefer April.
Dates.
Okay, so I'll make the motion. I make a motion. Now I know, Charlie, you had a draft resolution. Is that what?
Yeah, so just in the event that this board did do the DEIS, I did a template draft resolution that we use for all DEIS completeness and notices. You can make a motion now to deem it complete, subject to Ashley's final review. And the resolution that I have prepared follows those guidelines.
Okay, then I make a motion to deem it complete, subject to compliance with all requirements as set forth by AKRF, because it wasn't Ashley, actually, it was someone else at AKRF, I think, AKRF, and or both the requirements of AKRF and the requirements of the village engineer. And then it's deemed complete. So that's the motion. Oh, and if we need to set a date for the hearing, and assuming that that is completed by March, it's April 1st. April Fool's Day is our April meeting. which is a perfect time. So that 15 days before that would be like April 14th or something. So provided that it's all done by March 14th, we would set April 1st as the hearing. So that's my motion.
I second.
Okay, does that work?
I agree.
What, Greta?
I vote yes.
I vote yes.
And I vote yes as well. Okay, that's adopted.
Thank you, Ashley and Charlie, for helping us.
Yeah, of course. Secret is a confusing process.
Okay, I think we're done. That's it. That's all the items on the agenda. So we have.
Before we adjourn, I just would like to say that that summary that Charlie did last month, I thought was handy and helpful.
Yeah, I had asked him to do it, but because I wanted to make sure that I had asked him to give us a before the meeting because we'd had these issues before. I didn't want to have some of the things that came up last year where council didn't look until after. But I wanted, before we asked him to do it anymore, that was why I said all the board members should confirm that they want that. Was really wanted to make sure that everybody agreed that should be done.
I found it helpful, and then when I was looking at doing my review, it was helpful to kind of, that was the first thing I read before I looked at the documents again, was the summary that Charlie had.
I thought there were good summaries, and it also really directs us to the question that's before us. I mean, you know, at least you're putting something down. If I didn't agree with it, it's like, oh, okay, that's what you thought. I didn't, you know, it's directing us towards a particular question that's before us, which is very helpful, because I think sometimes we kind of get lost, like, what exactly are we attempting to do in this application? So that was very helpful.
Okay, Charlie, so continue.
Sounds great.
And I guess the other thing is to ask that whenever you send there was something in the, I guess you had some communications on the 130 Beach application with the attorney. I think it would be appropriate for the board to be CC'd on any type of communications that you have with an applicant or the applicant's attorney or the village, so that we are fully informed of what is, what's happening.
Yeah, absolutely. And I'll forward you those communications that I had soon. But yes, I completely agree.
Thank you.
Thank you all.
All right, there's a motion to adjourn. Meg or Greta?
Make a motion to adjourn.
I second.
So I vote yes.
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 Okay, this hearing is adjourned.
Thank you.
Good night, everyone.
Good night.
See you in March.